fresh admission item number 1.
In this case, for the annexure 1, my lord, I have applied for the certain work, my lord, by the annexure 2, my lord. They have selected by the annexure 3, my lord, to do certain works, my lord. I have completed all the work. The work has been certified by the opposite party 3, my lord. But they have not released the bills, my lord.
No.
That I have made a
Not a
request.
suit for recovery, sir.
No, not recovery, my lord. I am only
You have to file a suit. This is like
only
ask them to settle my bills. This is not writ petition is not for all this, sir.
only I pray our lordship direct
question.
this for the representation.
Writ petition is not. Sir, please study the law. For everything, writ petition. Somebody is not releasing your bill amount, writ petition. No question. No question, sir.
My lordship, permit to withdraw, my lord.
Contract.
Counsel the petitioner seeks leave to withdraw the present petition with liberty to seek other appropriate remedies as may be available to the petitioner in accordance with law. This post office withdrawn with liberty is granted.
Item number 2.
May I please, lordship. My lord, this is PIL on behalf of the villagers of Mallipur, Nimapur, and Udaipur of the district of Kendrapada. And because the government has sanctioned 21 crores 79,423 for construction of the road. That is from Kendrapada to Rajanagar. And that road was below standard for which, because they are not really constructed under the HPD contract. That's why the villagers applied for the authority for to supply the contract and to find out whether the specification in the contract is being maintained or not. But in spite of the petition several times, and my lord, given we were hunger strike, also the department is not taking any steps.
So where is Annexure 4? Please come to Annexure 4.
Yes, Annexure 4, my lord, yes.
Where is the proof of dispatch of this, sir?
My lord.
Acknowledgement. Acknowledgement by the authorities to whom you have submitted these representations.
Representations. That has submitted before the collector Kendrapada.
Yes, where is the acknowledgement?
Follow.
Acknowledgement.
Okay,
Receipt
acknowledgement.
Receipt of that.
That is there, my lord, but I have not submitted. But that is
And
there.
you submitted only on 14 February, sir.
Yes,
You submit on 14 February and when do you file this petition?
in February.
And immediately file this petition.
Yes, my lord. That is why I am filing the petition. Because, my lord, I have stated in my writ application, para 7. Para 7 I have stated
There is an acknowledgement.
that the opposite party of his contractor wants to complete the road within a short period and to receive the bills. If the villagers will wait for a period of 2
All right,
months,
the petitioner's representation, Annexure 6. The answer is in Annexure 6, sir. The acknowledgement is there. You have not studied your own paper book, sir. This is the problem. All right, the petitioner's representation at Annexure 6 will be examined by the collector. Kendrapada, and after notice to the petitioner and opposite party number 6. And after giving them a hearing, a reasoned order shall be passed thereon. Not later than 1st May and be communicated to the parties not later than 8th. The court clarifies that it is not expressed in that. All right.
Item number 3.
May I please, your lordship? Item number 3 and 5 are similar, my lord. What are the in this case? If your lordship will come to the rule 8.3 of the central excise rule, that has been challenged by
Central excise.
the petitioner, by so many assesses in different high courts, my lord.
It's still pending the Supreme Court.
It is still pending in the Supreme Court.
That's all right. They've chosen to follow some high court.
And the order has been stayed by the Supreme Court.
All right.
And but in the instruct case, the Lord has suggested by following the jurisdictional high court order, he has passed the.
No, the jurisdictional high court's order has been stayed.
No, that has not been stayed. But the jurisdictional high court order has relied upon the Gujarat order. That has been stayed.
All right. It is pointed out by Mr. Mishra that the
My lord, I'm giving the
Sestat has, in the impugned order, relied on the judgment of the Gujarat High Court, which has been stayed by the Supreme Court of India. Gujarat High Court, as regards striking down Rule 8(3) capital A of the Central Excise Rules 2002, which has been stayed by the Supreme Court of India by its order dated 24th September 2015 in SLP Civil CC number 16523 of 2015 bracket Union of India versus Insur Global Limited. List on
Your Lordship,
notice
similar
list on
matter.
1st May.
1st of May.
1st May, along with OTAPL number 16 of 2019. All right.
Your Lordship may issue notice so that I can file the requisites. my lord.
I have said
Obliged. 3 and 5 are same.
same 3 and 5.
Item number 4.
Item number 4.
Your Lordships will look at the last order. Actually, Your Lordships, we'll accept notice for NALCO, Your Lordships.
All right. Ms. Pamirat accepts notice for NALCO and seeks some time for his arguments. List on. 4th September.
4th September. Obliged.
Item number 6.
My lord, the question of law, my lord, the question of law, it's serial number 1 at flags T, your lords, covered by my lord's order in the Egmar case, your lordships, followed a copy of the same is produced, your lordships.
Yes, sir. Covered. All right. Say, admit the following question of law is claimed for consideration. Then the same order.
In the meantime, you let's see against this. In the meantime,
SLP is
we have tested that case of automobiles on Supreme Court, and against that review is pending. And against this ECMAS, we have not gone to Supreme Court. Recently, we have filed the SLP, and that SLP we are trying
With a delay.
Yeah.
Yeah, let's see.
You shouldn't delay.
Item number 7.
Grateful.
Lord, here, second order litigation, Lord, I have challenged the refund, Lord, refund order has been issued in as per the order of the commissioner, Lord, without any interest. Though, Lord, the additional commission stated that this collection is illegal and not sustainable in the eye of law. In spite of that, Lord, he has only granted, Lord, actual penalty without refund. Because, Lord, the act says, Lord, only arising out of order, only can refund interest can be given. So, Your Lordship, in similar matter has already issued notice over the entry tax matter, same assessing. I request, Lord, us issue notice.
Where is that order?
Yeah, that order is not.
Okay, you say notice.
Entry tax will not
Notice
be
accepted
already.
by Mr. Mishra on behalf of the opposite parties. Reply be filed within 8 weeks, rejoined to the next date. List on 14 March is too short a date, sir.
Yes, Lord. Earlier it was late. Past order, Your Lordship, and since.
Then this one you tell us when it's coming up. We'll give a long date for
Yes, Your Lordship. Yes.
list on 29th August.
I am permitted to issue notice to state also as a party here. State law department is a party because I challenge the legal validity of the section.
He accepts only for 3 to 6.
Yes,
And
Your
then I think Ishwar Mohanty for 1 and 2. All right.
Your Lordship.
Item number 8.
My lords, please, my lords. I appear for the petitioners. Manoj, this is a writ petition challenging an order rejecting my refund. Since the tribunal is not constituted, I filed a writ before this Honorable High Court. And on a similar issue for the earlier period in my own case, this Honorable High Court has already issued notice and has posted the matter for final hearing. Page 195, my lords, of my petition.
19th April.
Yes, my lords.
All right. Notice returnable 19th April. All right.
It should be tagged along with the other appeal.
Yeah, list along with reproduction civil 19998 of 2021. He accepts notice.
Yeah, opposite party number 2, 4, and 5.
2, 4, and 1 also, sir. Union Wind has 1 is also.
Copies have already been served upon the union, the state, and the central excise.
All right.
Extra copy may be served.
I'll serve extra copies.
Please, sir.
Item number 9.
Great.
Oblige, grateful, my lords.
Right.
May I please, Your Lordship, in absence of GST appeal, appellate tribunal, the appeal filed by the, passed by the
First
appellate authority,
10%, 20%.
10%. The corrected copy I have filed.
List of 31st August.
Item number 10.
Number 1.
Item 10.
Yes, my lords. Wait, please, Your Lordship. This is similar to, oh, 10.
10,
Sorry,
10.
sorry.
I was wondering.
Sorry, I'm sorry. I'm sorry. I thought that.
May I please, Your Lordship?
Yes.
My lord, in this case, the department has come up with the appeal, my lord, challenging the order of the tribunal. Lordship, kindly have a glance to page 8. That is the question, friend.
I know, 263. What is?
My lord, here
Why do
the
you keep
question is, my lord, whether, my lord, while, my lord, exercising this jurisdictional power, my lord, whether inquiry is mandatory or not, that has been, the tribunal has held relying on the order passed by the jurisdictional tribunal.
Correct.
That inquiry is must, but that is not the act shows, my lord, it is only, it is not mandatory, my lord.
That's all right. Inadequacy of inquiry. All depends on facts of each case, sir.
Well,
you see, the revenues of this appeal by the revenues directed against an order dated 29th August 2022, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, allowing the assessee's ITA number 223/CTK/2019 for the assessment year 2009-10. The said appeal was directed against an order dated 29th March 2019, passed by the Principal CIT, Sambalpur, under Section 263 of the Income Tax Act 1961 Bracket Act. Paragraph. Among the grounds on which the ITAT has set aside the said order of the Principal CIT is that the inquiry undertaken for revisiting the assessment order and requiring the assessing officer to undertake a fresh exercise was not preceded by any inquiry. So stop. Paragraph. As noted by the ITAT, open quotation, this is not a case of inadequacy of inquiry. Full stop. It is a case of absence of inquiry. Stop unquote. Paragraph. The view taken by the ITAT appears to be a plausible one and not erroneous in law. Consequently, the court is not satisfied that any substantial question of law arises. The appeal is dismissed.
Item number 11.
Item number 11. The other day, my lords issued notice, and I'm giving the orders.
Same order.
Same order, same order. Lordship will see on that day, Lordship though stated the notice on stay, but it has not been reflected. What I pray, my lords, that any
IA number is put, sir, on top.
IA?
IT and IA.
Yes, yes.
So it's notice.
Yes, IA number. Yes.
Same thing.
Same. 12th September. Again, happy Holi to both of our lordships.
Sure. In advance. Do the same, sir.
In advance.
Chimanka will give a good party.
That was the main purpose.
Yes, one have to enjoy it.
Oblige, man.
All right.
Item number 12.
Item 12 not pressed.
Not pressed. Dismissed.
Item number 13.
13 here. Petitioner's father-in-law was licensee for 22-23. Just after getting the license in 23 days, he expired. He was granted with environment clearance by the Pollution Control Board up to 31/3/2022. Thereafter, after transfer of license in the name of the petitioner, she applied for amendment and transfer of his name in place of his father-in-law. That has been rejected on the other ground, saying that you have applied for expansion of license. I have not applied for expansion of license. Annexure 7, my lord, Lordship kindly glance.
Anyway, notice, I think you have to examine it. Notice, Mr. Mon.
Lordship kindly glance, page 28, it is stated for transfer of his name.
You put all this impact assessment authority,
Yes, my lord.
pollution control board, everybody.
Not because they have, on the basis of into order Annexure 7, they have closed the sub, my lord, on 24 February.
All right, notice, the access notice for opposite parties 1 to 3.
No, I take notice to special mission.
Yeah, notice to the remaining parties by speed post.
Yes.
That's in addition. Tracking report will be placed on record. Reply be filed within 4 weeks of service of notice. 27th April, sir.
No, I have prayed for a stay of Annexure 7, my lord.
How?
Because, my lord,
That I have.
Can't be stay. That will be final relief in the
Then
interim
there is a
stage.
final.
yes, my lord, they have a wrong expansion of, my lord, I have not prayed for.
We have to decide that, sir. They have to file a reply.
My lord, notice in also miss case.
Yes, notice.
No, that's why I'm praying for a special messenger. Because I know that the lordship say that it will
I
be.
know, but still they have to file a reply, sir.
Yes, my lord.
So 26th April. We can not 27th, 26th April. All right.
Obliged.
Item number 14.
But the appellant here is the assistant professor.
Hmm.
He's challenging the order passed by the honorable single judge. Before I take your lordship to the merits involved, I'll like to hand over the writ petition before the honorable single judge because I'll be referring the facts from the writ petition before the honorable single judge. That your lordship may kindly accept it. I folded the relevant pages.
All right.
But though it is available on record for your convenience, I have prepared a copy and I have given it here.
There were 2 writ petitions, is it?
2 writ petitions. I have given those 2 writ petitions.
I see.
Well, here the student made a complaint against the assistant professor.
Right.
Now, the alleged incident of 2016,
Right.
Section 9, subsection 2 provides a limitation of total 6 months period to lodge a complaint. Now, the present complaint is 2 years after. That too, during the inquiry, she compromised. Matter was disposed of. Page 32 of the single judge writ petition, kindly see. Page 32. That is at page 32, my lord. Kindly see that it was compromised, and that to in the first inquiry it was said that it is barred by limitation. Page 32, man.
There was already a writ petition, is it?
Beg pardon?
There was already a writ petition.
I could not.
No, there was already a writ petition.
Yes, my lord. In fact, pursuant to the inquiry, let me just tell you, lordship, page 32, there was an inquiry. Inquiry was dropped on the ground of limitation and and also on the basis of the compromise between the parties. She agreed to settle the dispute. Now, after this, this settlement of the dispute and disposal of the complaint, she lodges a second complaint on the self-same allegation. The second complaint was inquired into. Now, during inquiry also, out of all, every charges were not proved. Every charges were not proved except a charge that I informed her father that the girl is doing some kind of illegal act in the premises. I informed her father. That is what my allegation charge proved in the second inquiry. Now, the second inquiry, I challenged pursuant to the second inquiry, they terminated me. Only on the basis of an allegation that I informed her father, they terminated me. I challenged both the things, my lord. I challenged the inquiry report in one writ petition and termination in another writ petition. So far as termination is concerned, I said that you could not have terminated me without a disciplinary proceeding. That was not accepted by the honorable single judge. Honorable single judge has set aside the termination. So far as the inquiry, my lord, the limited point is, learned single judge said me to go in appeal. That your lordship would kindly see, I had 2 points of jurisdiction. One is barred by limitation. Other is second complaint not maintainable at all.
No. Once the termination order is set aside,
right, my lord.
Just let's see the operative portion of the order.
Right. That is at page. Lordship would kindly see. Page 28 of my appeal, man.
Right.
Para 10 onwards, your lordship will find. Then the order pass is page 30, para 11. The impugned order of termination is set aside. Now, once setting aside my termination order, so far as the second inquiry is concerned, honorable single judge is relegating me back to the appeal, saying that section 18 of 13 Act says that I'll go in appeal.
Right.
But that in fact is not permissible.
Why?
Section 18 is a provision that says that the appeal kindly similar 13 Act.
You've set it out somewhere.
Lordship.
You've set it out somewhere? No.
Yeah, extracted.
You've extracted section 18 in the body of the writ petition.
Yes, we have. Have we? No, I'm sorry.
All right. Let's see the act.
Your lordship can take this. Okay. That in fact appellate provision is reproduced in the paragraph itself. Page 25, your lordship will find. Page 25.
25. All right. Yes.
Of the impugned order.
Appeal.
Kindly see. Any aggrieved person from the recommendation made on subsection 2 of section 13 or clause 1, clause 2 of subsection 3 of section 13 or section 1, so and so sections. Non-implementation of such recommendations may prefer an appeal to the court or tribunal in accordance with the provisions of the service rules. Application to the said person, application to this should be applicable. Said person, or whether no such service rules exist, then without prejudice to the provisions contained in any other law for the timing in force,
The person aggrieved may prefer an appeal in such manner as may prescribe. If your lordship, the statute, that is referred to service rules, that is obviously the statute of the university, my lord. That your lordship will find I have annexed in the report the honorable single judge. Lord, this is from writ petition 5175 of 2020. I have given that page 71. Rule 20, section 26. Kind. Right. Page 69, your lordship will find the appellate provisions.
The member of staff agreed by any order passed by the board shall be entitled to prefer appeal to the visitor.
In terms of the service rules, the service rules, that is what page 69 of my writ petition WPC number 5175 of 2020, that says an appeal lies against suspension penalties in the disciplinary proceedings, which has been caused by the honorable single judge. So that's the point. That's the point.
The penalty was termination.
Penalty was terminated.
So just against the findings in the inquiry, there is no appeal.
That's it. Saying on precise two grounds. One is barred by limitation. Two, second inquiry on section 10 is not permissible. You conducted an inquiry. You dropped it on the ground of compromise and limitation.
Just a notice. There's no need for any interim order. Mr. P.K. Rathul, learned counsel appearing for the
interim order, I'll be, because they have, after this disposal, pursuant to the report, they have again initiated a proceeding against.
All right. All right. You say, points out that the appeal under the rules applicable to the, this is a university, is it? Is this a university or a college?
It's a
institute. Okay. To the institution, appeal applicable to the, under the rules applicable to the institution in question. An appeal lies against the penalty order. Whereas in the present case, the learned single judge has set aside the penalty of termination from service and ordered reinstatement of the appellant. So it is accordingly submitted that the learned single judge could not have thereafter relegated the appellant to the remedy of an appeal against the result of the inquiry. So it is further pointed out that on the basis of the impugned order, a fresh inquiry has now been instituted against the appellant. It's a notice returnable 31st August. In the next date, no further steps in the fresh inquiry shall be taken against the appellant.
Grateful.
Item 15.
Your Lordship, on behalf of Dr. Lenka, Your Lordship.
Yes, please.
Your Lordship, Dr. Lenka's grandparent has expired. Your Lordship.
I see. Counsel, the appellant is stated to be in some personal difficulty today. List on 31st August.
Oblige, Your Lordship.
Item number 16.
May I please, Your Lordship? Petitioner is verge of retirement. He will retire on 30th of April 2023. He was under transfer under Annexure 1.
Yes.
The transfer order was remained on status order was there. He was continuing. Then, Your Lordship may kindly have a glance to page 26, Annexure 8. When he proceeded to join at the place of transfer, then he was not allowed to join. Pursuant to the letter number so-and-so, the collector Cuttack joining report submitted by Sri Narayan Mahali, section officer so-and-so, male, physically by himself, are hereby refused on administrative ground. Then the petitioner made a representation to the collector as per the order of this honorable court, and the collector at page 34, I will take Your Lordship, page 34, 4/6/2022, the collector, paragraph 4, my lord. The petitioner stated that he is a cardiac and urological patient and it is difficult on his part to move distance place. But it is ascertained from the petitioner declaration HRA that the present place of posting is Sadar Katak, Katak, is nearer to his residence than the previous office of the Sadar Tahsil, Katak. Hence, the claim of the petition has been rejected.
No, from where to where have you been transferred? That's not clear.
My lord, he has been transferred from Sadar Tahsil, Annexure 1, your lordship, from Sadar Tahsil to Sadar Block. Katak Sadar Tahsil to Katak Sadar Block.
What's the distance between these things, sir?
My lord, my humble submission only this much is, the collector passed the order on 4/6/2022 that he should remain at Sadar Block. We have no objection. But under Annexure 9, 2 days after, your lordship, page 27, Annexure 9. Same collector on 6/4/6/22 passed I should continue at Sadar Block. On 6/4, 2 days after, in pursuance of the order of the concerned collector, Katak so-and-so, the Honorable High Court and WPC number so-and-so, the Block Development Officer, Katak so-and-so, Section Office Mohali, petitioner, Section Officer hereby posted as Section Officer, Compensation Officer, Sadar Bahal Section, Collectorate, Katak.
Where is this?
2 days.
No,
Well,
where is
it
this?
is in a 3rd floor. It is a compensation, payment of compensation, which is the task is very difficult. And he is a cardiac patient. He has undergone surgery and he will return in the month of April, 31st of April, man. 30th of April.
So successfully you've not attended office now.
No. He is discharging that duties of compensation officer.
For 1 month you want not to work in that office. You've been working till today.
My lord, it is
For 1 month, what is that?
it is difficult.
Oh, no.
My lord, the same collector, 2 days before, he passed an order, I should continue.
So that now you've been continuing there, sir.
And
if you want to go, I'm sure you accumulated
needs a compassionate
I'm sure you have medical leave and all that you must be having.
No medical leave is there.
I'm
But
sure.
He is a sincere and honest officer. He needs
Nothing to do with that, sir. That's nothing to do with that. He said this writ appeal is directed against an order dated 18 January 2023 passed by the single judge dismissing writ petition civil 17509 of 2022 filed by the appellant, questioning his transfer order dated 6th April, right? 6th April 2022, whereby he was posted as section officer in the CO Sadar Bahel section in Katak. Full stop. Paragraph. The only ground on which the petitioner sought to resist the above transfer order is that he was a cardiac patient and that the office in question was in the 3rd floor and therefore was causing him strain. Paragraph. The appellant admittedly is superannuating on 30th April 2023. Full stop. Counsel for the appellant informs the court that he has been attending the office at the place of transfer. Full stop. The learned single judge has issued sufficient directions for favorably considering the appellant's leave application if it is filed with supporting documents. In the circumstances, the court sees no reason to interfere with the impugned order of the learned single judge. The appeal is dismissed.
only one sentence. His pension paper be made ready before his retirement.
What is that?
As per law, your
sir. No, please.
As per law.
It's all right.
Item 17.
Right.
17, what had happened, I was checking up, same day both petitions. So it was in online filing at that time. So we were trying to come to terms with that. So probably it has been uploaded twice. So 2 numbers have been appended. The earlier one, so I withdraw. The first one may be withdrawn. Second one, my lords, opposite party 4 just served the counter on me. Just
16889.
I'll file a rejoinder, my lords, to both.
Counsel to the
May I make a submit?
seeks leave to withdraw the present writ petition, since another writ petition civil 16885/2021 is already pending for the same relief. This writ petition is dismissed as withdrawn. In 16885/2021, you say rejoinder be filed for the next date.
I am appealing for the opposing party number 1 to 3, my lord. I have already filed preliminary counter affidavit. Second copy not filed. In course of the day, I will file second.
All right. May I make a submission, your lordship? Now, the brother-in-law is fighting this litigation for the other brother-in-law, my lord. So he is already there in the CAT in 08-451, challenging my qualification or disqualification, whatever it is. So whether still he wants to continue this PIL, let the
I'll file a rejoinder. Your lordship's order covers me.
and that was the preliminary.
Your lordship's
question
order covers me. I'll file a rejoinder to this, my lords.
while issuing notice. That was the question raised by my lords.
Question was maintainability on the limitation act.
And in fact,
Not
it's
on
not a
this.
person, it is a personal litigation.
They are related, is it?
Brother-in-law.
Own brother-in-law. Yes.
Yes.
My lords,
And he is there in the tribunal, CAT, in 3 matters. Yes,
My
3 matters are
lords,
pending in
local
tribunal. Same
standi-
issue. Another matter in the before the court number 3, my lord.
my lords, locus standi has been cleared by the Supreme Court that locus standi will not be a bar.
No.
Brother,
How is
this
it a
is-
public interest?
Yes, public interest. But in this case, in this particular case, I had cited all the judgments. Lordship has taken note of all the judgments, my lords, here in the order issuing notice.
He also admits that he is brother-in-law, he is close relation.
No, 5, para 5. That
It would make no
subject to the petitioner satisfying the code of the maintainability issue.
maintainability was on limitation.
No,
No, my lord.
You are
Last
related.
occasion, it was read that it is a service matter. How it is?
No, in service matter, law is no longer reciprocal. It's in service matter, quo warranto is maintainable, eminently maintainable.
Quo warranto says.
My lords,
You are a brother-in-law and you have other litigation going on.
my
This
lords,
is the 6th one.
my lords,
This is the 6th one.
My goodness.
let me
He is fighting 3 independent.
let me
Four.
my lords, let me get an opportunity to produce the counter. I'll file a rejoinder. Lordship may call it in 1 week's time, my lords. I'll give a reply. 1 week's time, my lords. Everything is, my lords. That there is nothing, my lords, which is not covered. There is nothing which is not covered by the Supreme Court judgment. My lords, on each and every point, my lords, I'll answer. Just 1 week's time, my lords. In each and every point, my lords, I'll answer this, the queries of the objections, my lords. Just 1 week's time. I just received the counter affidavit.
Now, what happened? Against whom he has filed, he has already taken a charge of the head of the institution, HOD in this department. He agree with this. He is coming a personal mandata and is head of his brother-in-law to file such application for, and litigation is going on in CAT.
I'm only praying for a week's time, my lords. Only 1 week's time.
Now, this Tushar Kanti Sahu and that Kanishka Das, how are they related?
Sister's husband, my lord.
My lord, that
Sister,
I've already
All the
pleaded that.
informations have been
I've
obtained
already pleaded.
through
No,
RTI.
Kanishka Das is the brother-in-law.
Kanishka
Yes,
Das, doctor is the brother-in-law.
And Dr. Manoj Kumar,
How is this
opposite.
petitioner connected?
Petitioner's brother-in-law, my lord.
Kanishka Das is petitioner's brother-in-law.
Brother-in-law.
Yes.
Sister's husband.
Yes, my lords.
And all these informations are through RTI, are brought by Kanishka Das. Sorry, Dr. Das.
That's right. And Dr. Das is questioning your appointment
My lords.
There.
in CAT.
In CATS also in High Court.
Oh, Kanishka Das himself has filed another petition in the High Court.
In High
No,
Court.
no, High Court, not his. High Court, my lords, a fact-finding committee was instituted. Based on the fact-finding committee's recommendation, I was already punished without any formal inquiry.
I mean,
Not me, Dr. Das was already punished. I'm sorry, my lord. He was already punished. So I am the lawyer, my lord. I am the lawyer there. He was already punished. So therefore, my lord, without an inquiry.
let's not entertain this. You have enough ammunition. You're firing already very effectively in those guns.
No, it has already been stayed by this honorable.
Then what more do you want?
The proceedings have been stayed.
Years has elapsed in the meantime, my lord.
This is all insurance.
Now it is sending a very
In case
wrong signal.
this will be still alive. Let's not. This is not.
No, Lordship, one my lords, in alternative, one more prayer, my lords.
that Lordship may direct the CAT to dispose of at an early date.
How my lord, this
Not in this. Actually, Dr. Kanishka Das is the applicant there. You can always pray for that.
Similar,
You on his behalf can pray.
Mr. Palit was not there on
From the
24.
counter affidavit filed, it appears that there is already a separate proceeding before the Central Administrative Tribunal Cuttack Bench in OA number 451 of 2022, filed by one Dr. Kanishka Das, who is none other than the brother-in-law of the present petitioner, Tushar Kanti Sahu. In that view of the matter, it will be open for Dr. Kanishka Das to pursue that litigation. And there is no need to have another petition seeking the same relief at the instance of his brother-in-law in this court. Full stop. In that view of the matter, the represented petition is not entertained and it is disposed of.
that both the case has been dismissed.
Yes, the first one is anyway he's withdrawn.
first one was a mistake, double uploading.
Or
mistake of the
or
Along with me, Mr. Bhukta is appearing both the case.
or
Item number 18.
And item 18 committed to withdraw, my lord.
or
Item 18.
disposed of his withdrawal. All right.
Item number 19.
Here, my lord, for reconstitution of the appellate authority, my lord, in the State Pollution Control Board. The lordship has already on last occasion directed.
My lord,
What
so
steps
far as-
they have taken, my lord.
Yes, yes.
And I have already given a order, my lord, of the Honorable Apex Court with
Just
in
now,
this
so
regard,
far
my lord.
as the chairman post is concerned, your
I think we've already, the recommendation is already made.
yes, recommendation of it.
So with regard
And so far
to
as-
the
no,
post
your
of
lord-
vice chairman, my lord.
Yes,
I was-
just now I am answering that.
Yes.
So far as vice chairman is concerned, last date your lordship has asked me to obtain instruction.
Right.
I have obtained instruction
Right.
that that letter, the printout copy is coming within 5 minutes. I will file it. The summary of the letter is that as per the Act provision, the state government notified the rules both under Water and Air Act. There is no provision of vice chairman post in the
I see.
Gazette notification number SRO number 426/98 dated 17/8.
So there's only a chairman's post.
Only chairman. Your lordship can note, this is a letter number 4175 dated 3rd March 2023 of the Department of Forest, Environment and Climate Change Department.
From Government of India.
From Government of Orissa, this is a communication to the Advocate General that there is no post of
Vice
and
chairman.
I am to place before your lordship.
All right. You say counsel, Mr. Mahanti Learned AGA for the government informs the court on instructions that as per the
SRO number 4, Gazette notification number SRO 426.
under the Air Act as well as the Water Act, there is no provision for the post of a vice chairman of the appellate tribunal.
Yes, ma'am.
Full stop. As regards the post of chairman, he says that the recommendation of the
Already your lordship
recommendation that regard is already
that is pending
processed.
before the Government of India.
Is being processed and is at present pending with the Government of India. They will dispose of this.
Yes, that's it. What I say, my lord. Earlier they had this vice chairman post, my lord. They are not extended. And
No, but there is no such post, sir. Under the law, there is no such post.
I will get back. Lordship may kindly provide that. My learned friend may provide that copy of the instruction. my lord.
All right. He states that he will provide the copy of the written instructions to counsel for the petitioner. Full stop. Okay. I don't know why we should keep this pending, sir. Why?
Only 1 week, my lord.
All right. The chairman's post is not notified. The chairman's appointment is not notified within the next 6 weeks. It will be open to the petitioner to revive the proceedings. It is disposed of. All right.
Item number 20.
My lord, item 20 and 21, 3 to 4 defect is shown, my lord. I will remove those defects by Friday.
Friday. What are the matters about, sir? Tell us.
It is a encroachment case is instituted since 2020. No action has been taken till date. In two early cases in 115 and 116.
2 different encroachers.
Yes, my lord.
Tahsildar Vasudevpur.
All right. Petitioner's representation, bracket, both in Annexure 5, bracket, will be examined by the Tahsildar Basudev 4 and after notice to the petitioner and opposite party number 4.
3, my lord.
No, in one it is 4, the other it's 3, I think. No, in both it's 4, sir. Opposite party number 4. Both it's 4. And after giving them a hearing, the reasoned order shall be passed not later than 1st May and communicated to the parties not later than 8th. Court clarifies it was not expressed to me. All right.
Item 22.
Item number 22, Your Lordship. In this petition, I am praying for inquiry into the cause of kidney-related disease in village of Golaga. Your Lordship, half of the villagers are suffering from the said disease. And many unreported deaths are happening in the said village. And because they are financially very poor, they are not going to the hospital, sir, Your Lordship. As per Dangadi CHC, they have reported 35 patients, but it is more than 35, Your Lordship. And there is no water supply in that said village.
Today there's a news item, I don't know, where there are several cities in Odisha where the groundwater does not meet the prescribed standards.
Yes.
The pollution level apparently is quite high in several cities. You want to, let's get the CDMO to inquire into it.
Yes, my lordship.
Notice, Mr. Manti accepts notice. The Chief District Medical Officer, Jajpur, is directed to undertake an inquiry into the complaint of nearly 200 to 300 people suffering from kidney-related ailments in village Kolagaon on account of drinking polluted water. Stop. The CDMO can constitute a team to visit the village, meet the villagers who were stated to be suffering, and ensure that they are provided immediate and adequate treatment. A camp would be set up in the village for this purpose within the next 10 days. We'll stop. If any further assistance is required, the Additional Chief Secretary Health will provide
the collector can give the assistance because it is within.
Yeah, the collector, Jajpur, in consultation with the Additional Chief Secretary Health, because if some more doctors have to be sent,
yes,
can arrange for the can facilitate the necessary arrangements for that purpose. We'll stop. A comprehensive report be filed before this court before the next date. We'll stop. List on. April.
Deeply obliged.
My lord, order may be communicated to CDMO and
communicated to the CDMO, the collector, Jajpur, as well as the Additional Chief Secretary Health.
Deeply obliged.
All right.
Item number 23.
May I please, Your Lordship. In the case, my lord, the government lands, my lord, which have been enclosed by opposite partner 6 to 9, my lord. Now the Tahsildar, who is the authorized officer to take appropriate action, my lord, to free the government land, which is registered in the name of the irrigation department. Since long this particular plot were being used for the playground, my lord, the village youth and students are playing, my lord. Now, the neighboring plot also belongs to the opposite part number 6 to 9, my lord. And another plot is also neighboring plot. Plot number 10 also, it is registered in the name of school, my lord, where the school is situated. Now, opposite partner 6 and 3, now by storing the materials, my lord, that trying to occupy, and the Tahsildar remains silent, my lord. Despite our sincere effort by making the repetitions and all these things, my lord, despite there is a specific law under OPLE, my lord, Tahsildar not taking this step, my lord.
All right, the petitioner.
And despite the order of collector also, my lord.
All right, the petitioner's representations. shall be examined by the
Tahsildar Baranga.
Baranga. And after notice to the petitioners and opposite parties 6 to 9, and after giving them a hearing, the reasoned order shall be passed not later than 1st May and be communicated to parties not later than 8th May. The court clarifies it is not expressed in the matter. All right.
Lordship, one thing, Lordship, there is a collector direction also to the Tahsildar, my lord, to inquire and report. Tahsildar not taking the step.
Anyway, now he'll do it. All right.
Item 24. And pardon to my lord, Pastor, I have filed the dates and spinosis, may can see the PIL matter, my lord.
Harichak police station. You want these two villages to be included, is it?
My lord, my villages include the Charichak outpost, my lord. I am within 15 kilometers from our village. I have no objection, no notice, nothing, my lord. I have made a representation before the OP number 2 and 3 and since 16 September 2022, my lord. That is pending, my lord.
Inclusion of villages under a particular PS, how the petitioner expects that government will issue notice. So there are so many villagers like you. The government will issue everybody notice that we are going to amalgamate. This is on geographical condition, considering the geographical situation, we are doing all these things.
So the ladies and the old person cannot move, my lord. Within 15 kilo, one river is there, my lord.
That is a different thing.
I have made the reference that is not considered.
No, you don't want these villages to be included in Charichak, is it?
Yes.
My reference is pending, my lord. Since 16 September 2022. By the annexer 2 series, my lord.
No, you want to go to the main police station in Charichak.
Puri in Nimapada is in the main, which is 2 kilometers from our panchayat.
He wants that these two villages should come under a particular police station, but the government has made it under, keep it under.
Take it to a father place.
Yes. And he says that I have not been noticed before such amalgamation. That is the only.
Anyway, let the representation be.
Just a minute, you will be obliged, don't worry. Home Secretary will consider, that is the allegation that the representation is made to Home Secretary. This is too difficult to, your Lordship may direct the Director General of Police because he is DG Police. He will consider.
Well, petitioner's representations be considered by the Director General of Police. OP number?
3, my lord.
3. And after notice to the petitioners and giving them a hearing, the reasoned order shall be passed in relation to their grievance, not later than 15th May, and be communicated to them within a week thereafter. The court clarifies it is not expressed in any matter.
Deeply obliged.
Although addressed to the Home Secretary, bracket. All right.
Item number 25.
For this, you say the petitioner will appear before the DGP along with the downloaded copy of this order on 10th April. Not 10th April.
My lord, may I suggest one thing? Let him make a press representation to the DG because this is addressed to Home Secretary. Let him make a press representation to the DG on this subject, and he will.
Or he can produce a copy and produce a copy of this of the representation addressed to the Home Secretary. A copy of this order be sent to the DGP. All right.
Item number 25.
25, my lord, both the matters covered by your lordship. One is ECMAS, another is, my lord, case about wells. I am, my lord, file 2 IA. One is suffusion of the sole proprietors, my lord, and next one is formulated, added the question of law.
All right, that IA 5 of 2022 is allowed. Both, I think there are 2 IAs in each matter.
Yes.
Both are allowed, dispensing allowed, amendment allowed.
Considered I have filed.
All right. And then admit the following question of law as framed for consideration. Question is whether in view of the decision in ECMAS residence.
First one is ECMAS, second one is...
in 86 it's ECMAS and second is Acacia Automobiles. The impugned assessment order requires to be set aside. And then this is both same orders. The question is answered in the affirmative. in favor of the SSC and against the department. The revision petitions are disposed of. All right. Much.
Item number 26.
26, Your Lordship, on behalf of Mr. Acharya, I pray for some 2 weeks time. He is unwell today.
All right. One
Copy may be sought, my lord.
Meanwhile, we'll cure the defects, Your Lordship.
Copy may be served, it's not sought.
All right. Copy of the petition be served on standing counsel of the department.
Obliged.
List on 2nd May.
Obliged.
Item 27.
My lord, it is covered by lordship assessment case of automobiles test.
All right.
The lordship needs some modification. The lordship, it is covered, partly covered by case of automobiles and partly covered by subsequent judgment. The lordship may kindly turn to page 29. 29 and 30. "29, 10 lines above, your lordship, just in the case at hand, it appears from the notice issued in VAT 307, the dealer was specifically informed about self-assessment 39, 40, 42, and 44, which is not disputed, by the dealer assessee before any forum. The dealer had also not taken any ground before the first appellate authority or before the tribunal initiation of proceeding under section 43 of the VAT Act was bad in law. And subsequently, your lordship may kindly turn to the next page. And the next page, your lordship, the finding is covered by your lordship's judgment. So far as that Pavanja sponge iron. Your lordship has modified this finding because this order has been passed after the case of automobile. Further, it appears, your lordship, at page 30, 10 to 12 lines below, your lordship. The material and record that on filing of the return computerized acknowledged, this part your lordship has already decided.
Has been communicated
Against the revenue. Your lordship, I just want to clarify the actual position because my learned senior only case of automobile. It is not covered by case of automobile.
That subsequent order, Mr. Kara's case.
Your lordship, Mr. Panda, learned senior counsel, Mr. Panda.
Correct. Pavan J. Sponge. Correct.
And Pavan J. Sponge, that paragraph 5.
That was because that entire period was not covered.
Your lordship, that is at page 9, paragraph 9.
Paragraph 9.
Paragraph 9, your lordship.
Correct. We say, admit the following question of law is framed for consideration, whether in view of the judgment of this court, dated 28 November 2022, in writ petition civil 10349 of 2016, bracket, Messrs. Pavan J. Sponge Iron Limited. Against this, no SLP yet, is it? Versus the Deputy Commissioner of Sales Tax, the impugned assessment order, and the corresponding orders of the ACST and the tribunal required to be set aside. It is seen from the impugned order of the tribunal that although the petitioner did plead that it was covered by the decision of this court in Messrs. Keshav Automobiles, the tribunal noted that such a ground had not been raised earlier by the petitioner, and further that there was nothing to show that, and that there was in fact a computer-generated acknowledgement of the self-assessment return filed under section 39 of the Orissa Value Added Tax Act 2004, bracket OVAT Act, paragraph. As explained by this court in Pavan J. Sponge Iron Limited versus Deputy Commissioner of Sales Tax, Supra, it is not enough that an acknowledgement is prepared, but it has to be communicated to the SSC. We'll stop in para 9 of the said judgment. It was observed as under paragraph. In that view of the matter, the question of law framed is answered in favor of the SSC and against the department, and the impugned order of the tribunal and corresponding orders of the ACST and the assessing officer are hereby set aside. The revision petition is disposed.
Now let's see, this order became more stronger.
We don't know all till the Supreme Court decides. All right.
Item number 28. May I please, my lords. First, this is a case where petitioner for lordship carries on various works contract in the state of Odisha under different government departments, my lords, and it is filing VAT return and also being assessed here. I have given to your lordship a few documents, my lords. Your lordship will find I have been granted clearance certificate by Orissa tax authorities till 2015-16, and also a revision order
stating that, so that I am a dealer in the state of Odisha, in respect of which various works contract which I have executed, those are being taken care of by tax authority of Odisha. But what has happened, in 2021, the Jharkhand authorities, in respect of very self-same transactions, works contract which I am executing in the state of Odisha, they have assessed me, in 2021, communicated order in 2022.
No, but tell this impugned orders are appealable one.
Appealable, but difficulties because I have spread in this application questioning the jurisdiction because I have referred to Article 226(2) minutes. I have also brought to your lordship's notice judgment of Honorable Justice Pardiwala in the case of
I know.
Bhavendra.
Even if Justice Dipankar Datta has given that judgment.
In those cases, that has referred to so many judgments on Apex.
Correct, the 226 is not a bar.
The whole difficulty is I have to go to Jharkhand to file appeal.
So what?
No, reason being,
Jharkhand is not some back of beyond, sir. Jharkhand is just north of Orissa.
The question arises, whether they have jurisdiction. Question is, if your lordship will see rule 3 of the service tax rules, it specifically says, my lordship, kindly see for a moment, they put it there. The officers, who appointment of officers under service
but
tax.
This can be raised in the appeal, sir. This can be raised in the appeal.
The whole difficulty, that was also what has happened. In February 2022, when the demand notice claimed, it came to my notice. Your lordship knows also limitation part also.
We'll always say that this period during which the writ petition was pending will be excluded.
No, just now we filed, Milords.
No, but that can be
only after receiving the demand notice, Milords, which was communicated in February 2023.
No, but is that that's not an outer?
That's praying, let my friend take instruction, Milords. I think
this is the second line of.
I think let them take instruction.
Good advocates will do this.
So that matter can be resolved.
Put it on him.
Let them, Milords.
Let's not entertain. Since the appellate remedy is available, it is the impugned order.
Milords, may I, Milords, your lordship permit me to withdraw to file better because many averments which I am filing right away, it was not in the court.
No, not in this. You will raise it in the appeal, sir.
Yeah, your lordship knows.
What we'll do is we won't say you are withdrawing. We'll simply say we are not entertaining.
That's what I am submitting, Milord. After seeing enterprise judgment, my lord's knows. Even the opinion authority also cannot help me in resolving the dispute.
No. Then ultimately you will file. You will say that against the order of that appellate authority, same what we are doing now, entertaining writ petitions. You'll only go to Ranchi.
No. Whether Milords, there is communication because my lord's knows. The question of filing appeal, all that relatable to communication, Milords. Because what I was communicating subsequent notice, Milords, which is a follow-up notice to recover the remand. That which has not been served.
All that, sir. In the delay application, you will probably try to convince the authority. And if they're not convinced, you will file a writ petition.
I understand, Milord, but what
because there's no second appellate authority yet.
I understand. What I'm praying for. Let me, Milords, incorporate all the details, Milords.
No, it's
nothing is there here.
That you will do it in the appeal, sir. You say the court is not inclined to entertain the present writ petition against the assessment order dated 29 June 2022 passed by the Assistant Commissioner.
31st January 2022.
Yes, sir. Oh, it came to my notice on 22/23. Annexure 2 series belongs. And the order is dated 10/1/2000. Hindi, they have written Hindi. Prerit पारित किया गया है, that means date of order is 11/1/21 and the date of issue is 37/2022, my lords.
No,
And
there are two, I think, two writ petitions in 5287.
At page 18, Your Lordship.
Page 18, my lords, kindly see. Turning page 18, your lords, see. आदेश पारित करने का तिथि, डेट ऑफ ऑर्डर 11/1/21. आदेश जारी करने का तिथि, डेट ऑफ ऑर्डर इज
1 minute. I think you're referring to 5419.
No, Your Lordship.
5287. 5287. 52, first matter.
Just show them the hard copy. Just 29 June. Just see annexure 1.
Then, Your Lordship, for the periods, I think the numbering has been altered. We have some problems since it was e-filed and there were different periods. We got the different numbers then, Your Lordship. According to us, the number 5419 is this order. That.
No, even in 5419, show the 5419 writ petition.
No. The same writ petition is numbered as 5419.
I don't know how it's happened.
Twice.
Yes, I think.
Then I should have the benefit of refiling once again. Let me refile, incorporate all the facts, but become a better application.
All right. Both say counsel, the learned senior counsel seeks leave to withdraw the present writ petitions, liberty to file proper petitions. In accordance with law, disposed of is withdrawn, liberty is paid for. All right.
Both belongs. 5419 and 5287.
87, correct.
Deeply obliged.
Item number 30.
My lordship, this is the petition challenge the annexure 1. The violation of natural justice, personal hearing not given.
All that is appealable order, sir.
Your Lordship,
Yes, for the 5 assessment period, 7/8/2021-22, Your Lordship, all these orders have been passed on 19th August 2022. And now the writ has been filed in 23 after issuance of attachment notice, even after passing the limitation period, Your Lordship.
My lord, this is come to notice of the petitioner on 6th February only.
Whatever. It's all appealable, sir. These are all appealable orders. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to file an appeal against the impugned orders in accordance with law.
Give 15 days time.
Yeah,
Your Lordship,
if such appeal is filed, not later.
Your Lordship may condone the delay. Your Lordship may direct to condone the delay, but the period only the.
Yeah, during which if such appeal is filed, not later than 20th March 2022. 23. Accompanied with an application for condonation of delay. Explaining the delay on account of the pendency of the writ petition, then to be considered in accordance with law by the appellate authority, the court clarifies that it has not expressed any in the matter. The petition is disposed of, is withdrawn with liberty paid for in the above terms. Right.
In any of the cases, are we condoning the entire period's delay?
No.
You come to court. They can only
In fact, we are saying we have not expressed any view in the matter.
Your authority should be meticulous.
Item 31.
Sometimes the authorities have misdirected because once Honorable High Court has directed, means Your Lordship, the delay is to be condoned. Your Lordship, for that reason only I need a clarification.
While arguing, you should be very careful.
Item number 31.
Item number 31, some defects are there, 2 weeks time to remove the defects.
First appeal, second appeal, I think.
Second appeal.
10%.
10,
order, same order.
In the meantime, I will remove the defects.
30th August.
Obligation.
Defects we removed in the meanwhile. All right.
Item 32.
32, my lord, there is my lord defects with regard to condonation of delay.
What's the delay?
I have filed, my lord, already I have filed IA. That has
14
not
days. All right. That IA taken on board. You have not filed it. You filed the
already filed.
What's the
That is
number?
IA number 68 of 23.
Taken on board, delay condoned. Yes. What's the question of law?
That is, my lord, lordship kindly see-
Amortization of expenditure representing lump sum amount of upfront lease premium.
There are other appeal, my lord, that may come along.
When
And some other-
this will follow, they will follow the same SSC.
Same assess.
So you tell her, argue here only, sir.
Let it come. They have to-
Haven't to frame the questions.
Yeah, he's there. It's there. Page 9.
I have not prepared, my lord. I thought there is delay. Lordship kindly to be taken up on 10th or 9th.
Where are those coming up? Not listed yet. Okay, at the request to consult the appellant list on. (18th April).
Obliged.
Item number 33.
Dispensing with allowed condonation of delays. Delays how much?
Delay, my lord.
90.
Yes.
That's condoned. COVID period.
Yes, my lord.
Deletion of addition of 8
You lordship, one
17 lakh.
question of law in you already decided against the revenue supply dam
Maintenance.
provision for dam, but so far as the only below two
Guarantee commission.
no, my lord. One issue your lordship has already decided. I'm just passing on the order. One question, lord. Two item 35 and 36 covered by 2. It is against the revenue. But in others, my lord, though dam, one question of dam maintenance there. In addition to that, my lord, other issues are there. One is, my lord, the commission state to the
1 minute. So items 35 and 36, you say in view of the decision dated 31st January 2023 of this court in ITA 9 of 2021, bracket Principal Commissioner of Income Tax /1 versus Orissa Hydro Power Corporation Limited, bracket. The present appeals are dismissed. The other three,
that's
33, 34 and
one question is not the dam maintenance. The other question is not I'm placing two another question is there. One is not just straight to see the running page in internal by 7 of my appeal memo.
This is an item ITA 30.
Yes, my lord. Question number B, my lord. There, my lord,
that's what calculating guarantee commission.
Yes, my lord,
having followed mercantile system.
Yes, my lord. Here, my lord, without my lord, commission, whatever paid, my lord, without deducting the same, he has continuously paid 500 total guarantee. And if you lordship see the government's notification that has been quoted in the appeal order, page starts from not in the appeal tribunal order, it is not in CIT appeal order. Page numbers start from 61. Excess 8.1. Excess provision for guarantee commission. Your lordship, the last paragraph, state government in finance department. May I please know?
Have prescribed the criteria.
The state of finance department has prescribed the criteria and guidelines to be followed for the government guarantee for loans by the public sector undertaking oblique urban local bodies, cooperative institutions and Companies Act in resolution number shown in para 7 of the unit emphasize that guarantee commission in any case of the guarantee shall cover the minimum amount of guarantee sanctioned irrespective of the amount availed or outstanding first of each year till liquidation of the loan. However, the approach guidelines subsequently clarified as detailed below. After careful considering the proposal, it is clarified that the borrowing organization shall pay guarantee commission the reduced amount on the repayment of loan amount time to time. If the financial institutions certify that loan or portion of the loan available to state government guarantee has been repaid, however, the guarantee commission will calculate it on the reduced outstanding guarantee with effect from past April. These blood issue following the guidelines, statute orders have made remark. Even then, Lord, it has been allowed in favor of the assessee, and the appellate authority also passed in against the
Is this a binding direction or something?
That's it.
Is this a binding direction as far as the SSC is concerned? The state government's.
No, my lord. It is a persuasive value, my lord. So therefore, my lord, if something is
There's
reducing,
no deliberate way,
Default.
It's not a deliberate evasion of tax.
no, there is no. But he is deducting the amount, like the actual amount of 5% with the whole. But when they're reducing, my lord, whatever amount has been paid, that has to reduce. That has been calculated by the AO. Supposing, my lord, 100
Let's see
rupees.
the IT80's order.
Yes, your honor. IT has not, that issue has been reflected in
Para 17. So there's an earlier.
Yes, my lord, earlier.
What did you do in that earlier year? 5, 6.
Earlier that not I have not checked. I mean, other question also about depreciation concern, my lord. 15% has been disallowed. Yes, my lord, simply say earlier it has been reflected. Therefore, no requirement to file the detail wise. But however, this year also addition has been made. If an addition has been made, it is a duty of the assessee to quantify the portion of deduction of the depreciation in which machinery or capital issues he has invested. Therefore, the depreciation question of law may be not.
Let's see what the IT80 does in that.
Yes, ITS must only say, turning page 18. He has allowed without elaborating last starts from internal page 18.
Oh, again, previous year, sir.
Previous year, accepted, if there is no addition in this assessment year, then your bow down, this should be accepted. But here, your lordship, see the appellate order clearly mentioned that he has been added. Let's see page 63.
No, the point is about consistency, sir.
No,
5, 6, you've already accepted the case.
No, accepted means previous year, whatever amount is there, subsequent depreciation allowed, accepted, no issue. If it has been added in this year, then he has to produce the detailed item-wise depreciation. He has not filed. You will also see page 63 of the appellate authority order. Appellate authority also disallowed the same lot. Lordship, same lot. Depreciation claim or miscellaneous assets. Last paragraph.
Yes.
In the assets schedule 5 of its profit and loss account and balance sheet under fixed asset and depreciation, claim depreciation of various heads under Companies Act 1956, however, while computing the total income basing on the tax report and annexed Annexure 3 schedule of depreciation as per Rule 5 of the IT Rule 1962 claim depreciation. In particular, assets subject to depreciation item claim in Annexure 3 of the depreciation schedule IT, provided claim of depreciation miscellaneous during the year against the opening balance of miscellaneous so and so. If some of his file was added during the year, depreciation so and so was claimed such as calculated depreciation 50 million gross particular assets, including the aforesaid miscellaneous asset. Therefore, my lord, these added, my lord, if something is added, in which item it was added, it has not been spelled out. All right. Lord, therefore, my lord, my humble answer this question because it has been disallowed by the first appellate authority also, my lord.
Correct. Consistent, concurrent views, sir. You say these appeals by the revenue. In these appeals by the revenue, this is items.
30.
No, 33.
Yes.
Sorry, 33, 36, and 37, 38, is it?
No, 38 is something different. 38, up to 38.
33, 36, and 37.
Yes.
In these 3 appeals, 2 questions are urged, which are directed against the common order dated.
Yes. 3 damn matters also there.
All right. Okay. Against the common order dated 22/6/2022 passed by the Income Tax Appellate Branch, Appellate Tribunal, Cuttack Bench, Cuttack. In ITA numbers, you have to put 3 numbers. For assessment years, you can put down those 3 years. The following questions are urged for consideration. In the first matter, that is ITA 30, it's at page 8. Yeah, page 7 and 8. As far as question number 1 is concerned, in view of the decision of this court, just be there, dated 31/1/2023 in ITA 9 of 2021. This court declines to frame question A for consideration since it stands answered against the revenue by the aforementioned order. Paragraph. As far as question B is concerned, it is seen that the ITAT has concurred with the view of the CIT bracket A, which in turn has relied on the previous decision for the previous assessment year 2005-06 in respect to the same SSC. Likewise, even as regards question C, the CIT A has simply followed the order passed for 2005-6. Paragraph. Consequently, the revenue is unable to point out if the said orders for AY 2005-6 have been appealed against by the revenue. So, in that view of the matter, following the rule of consistency, the court declines to frame the questions as urged. Stop. Moreover, these are concurrent views of the CIT-A and the ITAT, which turn on facts. Stop. Consequently, the court declines to frame the questions as urged. The appeals are dismissed.
Milord 38, Milord, I need some time because it is not similarly performance incentive. I Milord seek for instruction. So, Lordship, kindly take it on Milord 19th.
Okay. Power Generation Corporation. That's a different corporation. The others are Hydropower Corporation.
Yes, sir.
So 38 is the request of Mr. Satpathy Learned Counsel for the revenue. List on 2nd May.
Lordship, condone the delay 12 days and
or delay condone dispense with allowed.
Lordship, please.
Item number 39.
Batch of matters are already fixed to 30th of August. By
Same order. Notice, he accepts notice, reply within 8 weeks, which are the next statement. There should be a stay of the impugned order.
But there is no interim order here.
Achha.
Only a Lordship fix up on 30th of August.
Okay,
No interim
list
order.
on 30th August, along with petition civil 8072 of critical. On it.
Let's go. Item number 40.
None please dismissed.
Item 41.
Not present. Not present. Dismissed. Memo taken.
Item 42.
My lord, in item number 42, petitioner here is an OS shop licensee, my lord. Petitioner grievances government in the year 21-22 has not considered relaxation with respect to waiver of MGQ so far as the closure of shop with respect to that weekly lockdown and weekly shutdown is considered. My lord, my representation under Annexure 7 is pending.
All right. Petitioner's representation shall be considered by the Excise Commissioner.
By the principal, opposite party number 1, Principal Secretary to Government. He is the authority to grant relaxation, my lord.
Mr. Monty?
Yes.
All right. By the Principal Secretary, Excise Department. And after giving the petitioner hearing, recent order should be passed not later than 15th May and communicated to the petitioner within a week thereafter. The court clarifies it is not expressed anywhere in that.
Item number 43.
May I please, Lordship? Here the petitioner is a off-shop licensee. In response to the public notice at the instance of OP number 5 for on-shop, I have filed my objection, that is Annexure 3. Without considering my objection being a licensee, they have recommended the matter, the collector as well as the commission to the government. Because there is my MGQ is fixed at higher stage, my lord. To that effect, I have lost.
By 31st has to come.
By the government. By the government, my lord. Because once it is.
How do you know your objections have not been considered?
That Annexure 3 has not been taken into consideration by the collector as well as by the commissioner. It could have been disposed of by the collector. They have simply recommended. All problems, all Lordship knows after settlement of shops. For livelihood, they are coming up for on-shop license.
No, who's for this Janki restaurant?
Janki is the OP number 5 restaurant. He has submitted an online application for on-shop license at his restaurant, my lord. Being a licensee of OFSOP, I have submitted my objection.
How do we know if the decision has not already been taken?
Page 17, your lordship may see, page 17. A 15 days public notice was issued for inviting objection for the proposed site. In response to the said notice, 52 numbers of petition, that is 41 petitions favoring and 11 petitions against the proposal have been received within the stipulated time period, and all these petitions have been duly inquired by the Inspector of Excise, Jajpur Road, and submitted report by letter number so and so. It is also reported by the Collector Jajpur that the proposed site is very busy area with floating population coming under the Kalinganagar so and so. So all the objections which are received within the time period, including his objection perhaps, because he has that is considered. Now he will say that it is not considered, but documents on record reveals that it is considered.
Blindly they are preparing mallet. Not at all considered mallet. Not at all considered mallet.
So these things.
Let him take the final call. You can challenge that.
Yes, let him challenge the final. It's a recommendation.
Final, nothing remains. Once license you get, it is too difficult to challenge mallet.
Difficult to challenge is one thing, but you can challenge.
That can be mallet, but it is too difficult.
All right.
Because for augmentation of revenue, the state government blindly recommending the case to the government.
You yourself, when you are appearing for the licensee, you are saying that all these things should be. On 9th, you have got a case. Don't worry. I will. On 9th, you have got a case.
That my lord's
Sonalika Mehra versus State of Orissa.
That
I have filed the counter affidavit.
My lord's judgment is there. Very much.
That's on 9th, he has got a case just opposite what he is.
No, my lord, that judgment where I was arguing counsel relating 30 through 2, my lord. Any objection filed after.
We will argue that on 9th.
So here, my lord, my objection had not yet been considered. Let government consider before passing any final order, my lord.
Each stage they will consider, the collector will consider, then commissioner will consider again.
We are paying, my lord.
Each state they will get an order from
India officers lines are paying more than 2 crores revenue to the government. Government is getting more than 2 crores revenue from my sub, my lord. If it is done, then definitely there will be loss to the business.
That means you are also earning crores from
crores.
If you are paying 2 crores royalty. କଣ କୁଆଡେ ତୁମେ କହୁଛ?
ମୁଁ କଣ କହିବି?
2 କୋଟି ଟଙ୍କା royalty ଦଉଛ ଯେ
ଆପଣ କହୁଛନ୍ତି ନା ମୁଁ କହୁଛି?
ମୁଁ କାଇଁ 12% ତା ଦେହରେ ଭାବିଛି.
Does reflect that all the objections received have been considered. So at this stage, the court therefore would not like to go into the further question whether the consideration was adequate or inadequate. Stop leaving it open to the petitioner to urge appropriate grounds as and when the decision is taken by the government. The petition is disposed of.
Item 44.
I'm for the appellant, may I please? My lord, order dated 20th July 20 CMFL 405, it has been restored. And here this application has been filed, delay of 6 days.
All that condones now come to the main judgment.
My lord, allow 2 weeks time to plead again. Next for another 2 weeks time.
For what? No. 2012 appeal, sir. No question. Tell us what it is. Some labor matter.
Yes. My lord, the appellant is challenging the order of this single judge regarding this full back wages, and it has been dismissed. And this order has been combined.
How is a writ appeal maintainable? Labor court challenged in writ petition. How is writ appeal maintainable?
My lord, writ petition combined judgment, and a single judge is passed and order dated.
How is writ appeal maintainable, sir? That's 227. Writ appeal is not maintainable. The impugned orders be passed by the learned single judge in exercising jurisdiction under Article 227 of the Constitution against the award of the industrial tribunal. Consequently, in view of the judgment of this court in Mohammed Saud versus Sheikh Mehraj, the present writ appeal is not maintainable and is disposed of as such. It will nevertheless be open to the appellant to seek other appropriate remedies as may be available to the appellant in accordance with the audit. As affirmed by the Supreme Court in the same concept, 2010 release. Right.
Item 45.
May it please your lordships. The appellant is the development authority who has challenged the order of the honorable signatures.
Respondent number 1 is not served. You are appearing.
My lord, I am.
You are ready.
What I say, my lord, is that though in the writ appeal, the grounds of appeal I have taken is not that difficult, but to explain those grounds of appeal, a death charge is required, my lord, very much, and I was ill for last 1 week.
All right.
So a small adjournment so that I will prepare a death charge.
After the impugned order, what's happening?
Nothing has happened, my lord. They have not implemented the order of this honorable court.
And you also did not ask for
My lord, I have filed a content application, my lord, first content application, my lord, your lordship has disposed of. My lord, again, my lord, second content application is pending. My lord, they have taken the stand that the writ appeal is pending here. That all the time, my lord, they are taking the stand, my lord.
Counsel, the appellant wants an adjournment saying that he needs to prepare a list of dates. It is made clear that the pendency of this writ appeal will not preclude the court dealing with the contempt petition proceeding in the matter in accordance with law. List on 13 July.
Well, I beg your lordship's pardon, my lord, regarding the contempt application. I have already submitted my preliminary show cause reply, my lord.
Whatever.
So,
whatever. Yes.
Item 46.
My lord, 46, this batch of case, my lord, that relates to that Sarat Parida case, my lord. I am passing over a copy of the same. But sub-item 5, my lord, WA number 224 of 2021, that is a different case, my lord. Your lordship may kindly delink that, my lord. 224 of 2021.
When is the Sarat Parida matter?
8th May. I am passing a
WA 224, you say list on 8th May. 224 is which matter now? Priyanka Nayak. Somebody else is appearing.
In addition to that, your lordship will find in the weekly list, I have given the item numbers which are also Sarat Parida matter. In the weekly.
When it's taken up, we'll point. This WA 224 of 2021, you just say none appears in the system. Right.
Item number 47.
Pray 2 weeks time to remove defect, my lord.
List on 17th April, 18th April. Defect be removed in the meanwhile.
Item 48.
Lord, the short point for consideration here is, Lord, if an estoppel will operate against the regulation, under the regulation page 51, if Lordship could kindly see on the Council of Higher Secondary Education, that says, my lord, page 51, regulation 120, that says that if a candidate fails in one subject or group of subjects, he will have to appear against in the same group of subject, irrespective of the fact that he passes in one out of the group. Here, the candidate has failed in 2 subjects. Next examination, he doesn't appear in 2 subjects, he appears in 1 subject and passes out there. Next also, he appears in 1 subject and passes out. So point is, the regulation says that in these cases...
Why is he allowed to take like that?
We did not allow him. He filled up forms and appeared in the examination. The college, in fact, committed the mistake. College should not have allowed him to fill up the form. And the only mistake is...
The candidate prepares and he appears and then passes and then you tell him, no, you have to appear in all subjects.
No, that's our regulation, Lord. We take
No, I know. But what happens if he's allowed to take the exam?
But he is allowed to take...
What is his mistake?
But he is allowed to take exam in respect of the subjects he fills up the form. That's the point. He fills up the form and ask us to allow us to appear in the exam. He doesn't fill up the form in respect of the subject which he is required to. We don't scrutinize the application in respect of which subject he has failed, in respect of which subject he is filling up the form. He is filling up the form and approaching us that I'll appear in the examination. Regulation says...
No, you are the one issuing the hall ticket, I'm sure. You're processing that application form. Correct?
It's done in the college level.
No, but you're the higher secondary, whatever. No?
We are the council. We conduct the examination. The form is filled up at the...
No, form is for who issues the hall ticket?
Admit card, we issue it, man.
So when you issue the admit card,
correct,
you have to know the roll number. You'll know from the previous exam Whether the man has passed in one, failed in another, whether he should be permitted.
Publishing the results.
But they are all there, but then regulation prohibits that he can't be declared pass.
Once you issue the hall ticket, then you turn around and say, no, you should not have, we should not have let you do it. You should have appeared in all.
Look, we in fact are
not once, twice.
We are not once.
No, you said the second time he appeared in another subject.
Kindly see those mark sheets, madam. Kindly see.
No. There's something at your end which you have to tighten up, sir. The whole procedure at your end you have to tighten up.
In fact, we do not scrutinize the application in respect of subjects which he fills up the form. The law requires that he will fill up the form.
If this requirement of the law is there, that he has to appear in all subjects, even if he fails in one.
Yes.
Then at your end, you should not issue him the admit card at all.
The council should not have, but then council
will confine it to the facts of the case. Sir.
That your lordship.
The present appeal is directed against a judgment dated 21st October 2022, passed by a single judge, allowing writ petition civil 9988 of 2022, filed by the respondent. And directing the present appellant, that is the Council for Higher Education, by a second reason. Secondary education. Issue the +2 science annual examination pass certificate, 2021 pass certificate, bracket compartmental, in favor of the respondent. Paragraph. The grievance of the appellant counsel is that the respondent was, as per the applicable regulations, required to appear in all the subjects in a particular grouping, even if he failed in one of them. So in other words, according to the appellant, the student would not have appeared only in the failed subject by way of a compartmental examination. Paragraph. The fact remains that the respondent was issued the single course hall ticket to appear in the exam for which he had applied for, notwithstanding that he did not apply for the other subjects in which he had passed. As noted by the learned single judge, the appellant was stopped from declining to issue the pass certificate in respect of the subject in which the respondent passed by way of a compartmental examination. Paragraph. It appears that the appellant has to tighten its procedures to ensure that a student is not permitted by it to sit for an examination only in the field subject and not in the other subjects in that group, if the regulations in question have to be strictly applied. Confining the impugned judgment of the learned single judge to the peculiar facts of the case and clarifying that it would not constitute a precedent, the court declines to interfere. The writ appeal is disposed of in the
Yes.
Great.
Highly obliged.
Number 49.
Application for dispensing with filing of certified copy of Annex 2.
All right, that's all allowed. Yes.
My lord, the judgment and order passed under Annex 2 by the Honorable Single Judge. So also, the order seeking modification of judgment passed by the Annex 4 are the subject matter of challenge before my lord. Here is the case, my lord. The respondent number 1 moved mutation cases for correction of record of right in his favor, and those mutation cases were moved on the basis of a will. Tahsildar rejected all the mutation cases on the ground that the will has not been provided. That was challenged in the writ petition, my lord, even though appeal provision is there. The Honorable Single Judge, while entertaining the writ application, my lord, allowed the mutation cases and directed the Tahsildar to complete the exercise within the period stipulated in the order, my lord. Honorable Single Judge also came to hold that there is no legal embargo in disposing of the Miller.
There's already a civil suit pending.
Yes. Civil suit is pending.
That point.
And the Honorable Single Judge has said that the decision on the civil suit will be binding on both the parties. So this mutation order will no way prejudice the appeal.
It will abide by the result of the suit.
It will be abide by the.
You say the present appeal is directed against an order dated 25th January 2023 passed by the single judge, disposing of its petition civil 19-001/2023 filed by the present appellate, questioning the orders passed by the Tahsildar allowing mutation. No, declining to allow mutation on the basis of a will. On the ground that the will has not been probated. Paragraph. As noted by the learned single judge, since the appellant has already approached the civil court by filing CS number 99 of 2021, it is obvious that any decision taken in the meanwhile in regard to mutation would have to abide by the decision in the CS number 99 of 2021. The court is unable to find any error having been committed by the learned single judge. The appeal is accordingly dismissed.
Item number 50.
Item 50, your lordship, I prefer pass over, your lordship.
All right.
51.
It may please your lordship, my lord. A delay in filing the appeal on the ground that the order was reserved on 23/9/2022. It is not listed. It was not listed for pronouncement of order. Therefore, subsequently, I came to know that on that same day, the order was passed. Therefore, delay is caused to file this appeal. Order number 5, my lord, order was reserved. This matter is taken up to hybrid mode. Our learned counsel parties, hearing concluded and order is reserved.
Where do you get that?
Well, it was on the same day, 23/9/2022.
Where's that order proceeding saying it's reserved?
Your lordship, kindly.
Oh, I see.
It was not listed for pronouncement of the order, but I subsequently came to know that order was pronounced on the same very day.
When was it uploaded?
My lord, this was not uploaded. The impugned order which I have challenged under Annex 2 was not uploaded.
Not uploaded?
Not uploaded.
Just check. Uploaded now or even now it's not uploaded?
Even at present it has been uploaded.
Then it was not uploaded.
No, then it was not uploaded. And it was never listed for pronouncement of the order. Therefore, delay was caused in filing this appeal. And the sole question in this appeal that the charges which have been labeled against the petitioner, my lord, there is no charge that due to the misconduct of the petitioner, there is a pecuniary loss to the government. Charges was that, my lord, that the house of the petitioner was raided by the vigilance youth and they found some disproportionate asset, my lord. Therefore, he was arrested and kept in the jail and charge is, your lordship can come to page 20 to what are the charges, my lord, against me, my lord.
No. But the final order has not been passed by the government.
Government, no, my lord. Final proceeding has been initiated at the time of while I was in service, my lord.
Correct. And that's continued after your retirement.
I retired or continued up to, I retired on 31/3/2022, my lord.
All right.
Thereafter, the proceeding continued. I filed the petition before the Sonor court that after retirement, this proceeding which has been initiated against me, it cannot be, my lord,
prosecuted, cannot be cannot be proceeded as there is no pecuniary loss to the government due to my misconduct, my lord. Vigilance case is there, my lord. If criminal case I am found guilty, then all the properties of my confiscated. But the charges is the misconduct. There is no charge that there is a pecuniary loss to the government due to the said misconduct. Your lordship, I'll come to page 18 of the brief, my lord. What are the charges, my lord?
No, but there is a criminal case pending against you, sir.
My lord, gross misconduct and negligence in duty, failure to maintain absolute honesty and integrity, failure to discharge official duty and carrying out order of the authority. Next page one, imputations. What are the imputations, my lord? That's Amaresh Kumar Patra entered in the government service as junior MBI.
No, let's see 7.1 and 7.2a.
7.2a, my lord. That has already been decided in one case that has not been taken into consideration. I'm placing the rule 7 of the pension rule, my lord. My lord, right of government to withhold or withdraw pension, my lord. The government reserves to themselves the right of withholding a pension or gratuity or both, either in full or in part, or withdrawing a pension in full or part, whether permanently or for a specified period, and of ordering recovery from a pension or gratuity of the whole or part of any pecuniary loss caused to the government, if any departmental or judicial proceedings, the pensioner found guilty of grave misconduct or negligence in the duty during the period of service, including service rendered on re-employment after retirement.
The latter part, there is a
then my
proceeding.
Sub-rule 2,
There's
my
also judicial proceeding.
yes, my lord.
Sub-rule?
Pardon, my lord.
Sub-rule? 2.
Sub-rule 2. Yes, such departmental proceedings referred to in sub-rule 1, if instituted while the government servant was in service, whether before or his retirement or during his re-employment, shall after the final retirement of the government servant be deemed to be a proceeding under this rule and shall be continued and concluded by the authority by which they were commenced in the same manner as if government servant and had continued in service, my lord. This has been, my lord, answered by division bench of this honorable court. I am giving that decision, my lord, to your lordships, and I will place those decisions. My lord, your lordship, I'll come to para 13. I placed para 13, 14, 15, and 20, my lord. Learned additional para 13, my lord. Learned additional government advocate appearing for the opposite party.
1 minute, 1 minute, sir, 1 minute. Let's get to the facts.
Facts, my lord, that the petition
was there a criminal proceeding pending there?
No, their criminal proceeding was not pending.
So 1 minute. That's a clear distinction between that case and this
criminal proceeding. But charges here, there is no pecuniary loss to the government. Your lordship can see.
No, you can't isolate it. 1 minute.
My lord, it will be double jeopardy now. It will be double jeopardy. Now, my lord, they will say that it will recover from you. There is no pecuniary loss to the government as per the charges, my lord.
See, you are making a mistake.
My lord.
Criminal proceeding and disciplinary proceeding on the same set of facts can proceed.
Same charges, same charges.
Correct. They can definitely continue. Whether it's the criminal proceeding or disciplinary proceedings, they can simultaneously continue. There's no difficulty.
My lord,
there's no question of double jeopardy here.
My lord, if there is no pecuniary loss to
only the standard of proof is different, sir. Otherwise, on the same set of events, you can have two parallel proceedings.
My lord, my humble submission of before lordships, what I am emphasizing, my lord, if charges are there, and in the charges there is no allegation that due to the misconduct there is a pecuniary loss to the government and is to be recovered from the pension.
So that we will not know before the whole proceedings ends.
No, that charges itself, there is no, my lord, there is no charges that there is a pecuniary loss to the government. Your lordship, kindly see the charges. That is only, I have to, my lord, emphasize on that. If in the charges there is, my lord, in imputation, your lordship, kindly see. What are the imputations on me? Yes. On the basis of what the charges have been framed?
Yes.
Whether there is a criminal law, pecuniary loss to the government or not, my lord.
Yes.
Therefore, I am placing, my lord, page 10 of my brief.
All right.
Imputation. My lord, can see I am placing that.
Right.
That's Amaresh Kumar Patra entered into government service as junior MBI on 4/2/1989 and thereafter worked at different places of the state. Subsequently, he was promoted to the rank of MBI and worked at STA, Cuttack, Puri, Bhubaneswar and Jagsonpur. Being promoted as RTO, he joined as RTO Baleshwar on 30/5/2014 and continued in the same post till the date of his house search. That's the Amaresh Kumar, second, my lord. That's the Amaresh Kumar Patra. While working as RTO Baleshwar, his houses were searched on 25/10/2017 on the strength of search warrant issued by Special Judge Vigilance, Cuttack, in Cuttack Vigilance case number 11/2017 and subsequently Cuttack Vigilance PS case number so and so under section 13(2) read 13(1) DA, my lord. That is professional asset. PC.
In a DA case, can you possibly argue in a DA case?
DA case. It is a DA case.
1 minute. Yeah. In the DA case, if you are found guilty,
yes,
there is no pecuniary loss to the government.
Well, in DA case, if I am found guilty, my lord, if I will be found guilty, then the property disproportionate to my asset shall be confiscated, my lord, by the court itself.
Maybe, sir.
That court itself. Therefore, there is no pecuniary loss to the government to recover from my pension. Whatever will be recovered, my lord, that will be recovered from my asset, my lord. That will record my asset, all will be confiscated. That is generally it is being done, my lord. It will be confiscated from my asset, my lord. All the asset will be confiscated. And there is no question to recover from my pension, my lord. You'll also kindly see that there is no recovery to my pension in a disciplinary proceeding. It will be concluded, my lord, what is the asset? The disciplinary proceeding, my lord, it can be concluded what is the pecuniary loss to the government. It will be decided in the vigilance case itself that what is the pecuniary loss that is to in respect of the whatever is my income during my service and what are the asset values of asset on the basis of evidence.
Difficult.
Then what will be the disproportionate?
Difficult to argue in a DA case there is no pecuniary loss.
Well, that will disproportionate will be confiscated. That will be the punishment, my lord, will impose on me.
It's not so simple.
Well, how can it will be recovered from my pension, my lord?
Sorry, we don't agree with you.
You also can see that what is the imputation, my lord.
Because all your argument at this stage you can. We are not with you that in a DA case there is no pecuniary loss to the government. We are not with you on that. If you want to argue, you argue. We'll give you a finding on that. Then don't say, sir, this will prejudice my inquiry. If you want to argue, please argue. We will not stop your argument.
Lord,
but if you start dealing with those arguments, don't say, sir, this will prejudice my case.
My lord, my lord, your losses are made up the mind, my lord.
We're permitting you. This is what we prima facie are saying that we do not agree with you. If you say, no, let me fully argue it, by all means argue it. But if at a later stage we are not with you, don't say, sir, this is going to prejudice my case. That's all we are saying.
No, my lord,
this is a chance you take.
That will affect my lord.
Obviously. You keep your powder dry, sir. Let me. You see, one of the points urged by Mr. Monty, learned counsel for the appellant, in assailing the impugned order of the learned single judge, is that unless there is a specific charge that the conduct of the appellate caused single court's pecuniary loss to the state, the disciplinary inquiry cannot continue beyond the date of his retirement. Paragraph. The learned single judge has not agreed with this contention in view of the interpretation placed on Rule 7.
My lord, I may pardon, I will withdraw my appeal. It will better.
All right. Counsel for the appellant. Discretion is a better part of valor.
Yes.
Counsel for the appellant seeks leave to withdraw the present appeal. Disposed of as withdrawn. All right. Yes, sir.
Item number 52.
This regarding the illegal detention, arrest and false implication of an advocate of this bar, my lord. She prayed for compensation as well as criminal prosecution. Now today we are filing the rejoinder. In the meantime, all the opposite parties, they have appeared and filed their common counter, my lord. So the noting is not necessary at present.
All right. Counsel to the petitioner states that he is filing his rejoinder during the course of the day today, with a copy being served on counsel for the state.
Today, I have already served.
All right. All right. List for hearing all. August 16th. Right. Yes.
Item 53. May I please join?
Yes, please.
This petition has been filed in the form of PIL in challenging a government grant allotment in favor of opposite part number 5 under Annexure 2, where none of the procedures as approved under the law has been followed, and this grant has been given at a stage when the election for the assembly election was over, and the next date, and the government who has granted the lease, that government has lost in the election, and the next date of election on 26th, this allotment was made, and your lordship kindly see your lordship's order dated the 12/4/2021. Your lordship's order. Because the CAG, by conducting inquiry in 2012, has heavily commented on this allotment lot of 10 acres of odd land in favor of the opposite part number 5, and the CAG has characterized this allotment as the encroachment. No law has been followed, nothing has been followed. So therefore, your lordship, by referring to the CAG report, has directed the government to file the necessary affidavit. What action you have taken? Till today, the government has not filed any affidavit, and one affidavit has been filed, my lord, that is not in compliance with your lordship's order.
What is that affidavit? Let's see
that affidavit, and the GA department has filed that affidavit, my lord, that is on 3/5/2021.
Item 53. 53.
Yes, GA department. And your lordship kindly see that affidavit. What your lordships directed and what reflected in the affidavit.
The Deputy Director of States.
Well, that is on 3/5/2021. Opposite part number 6 and 7 have filed that affidavit.
Right.
But what they have said, that we have taken step.
No, the deponent is the Deputy Director of Estates, correct? It is Sri Raut.
Yes,
the deponent of the affidavit is the Deputy Director of Estates, correct?
Deputy Director of Estates.
So which
Deputy
paragraph?
Director of Estates.
Which paragraph are you referring to?
That your lordship can see the paragraph 3.
3.
Yes, sir. And in response to paragraph 3 of the additional affidavit filed by the petitioner, by way of an additional affidavit, we have produced the report of the CAG, Lord.
Right.
Upon which your lordship directed.
Right.
That in response to paragraph 3 of the additional affidavit filed by the petitioner, it is submitted that the government, after careful consideration, have allotted area measuring 232 decimals. So-and-so, corresponding to drawing number so-and-so, order dated so-and-so 26/2/2000, in favor of the opposite part number 5, Hotel Mayfair Resort Ltd. The allotted area corresponds to the revenue plot number so-and-so. Then, that in response to further course of action, your lordship, paragraph 4, it is further submitted that after allotment of the land, further course of action such as execution of registered deed, registered lease deed, and issue of rent intimation to the Tahsildar have not been taken up, as the classification of the land is found to be jungle. Then your lordship, the In that paragraph, they are saying that that land is still lying vacant. And in paragraph 5, Your Lordship, you can turn to paragraph 5 now. In response to paragraph 4 and 5 of the additional affidavit filed by the petitioners, it is submitted that the chapter 2 of paragraph 2.1, 2.116 of the report, that is not the direction, Lord. Your Lordship has specifically directed that what action you have taken in respect of paragraph 2.1.11.3, 2.1.13.3, and 2.1.13.4. There is no reply with regard to that observation of the CAG. 2.1 to 2.116 of the report of the Controller and Auditor General of India on General and Social Sector, Volume 3, for the year end March 2012, relates to allotment of government land by the General Administration Department in Bhubaneswar city for various purposes. That in paragraph 2.1.16, the following recommendations were made by the CAG for consideration of the government. Formulation of procedure for allotment of land which transfers discernible and under a well-defined policy made known to the public. Demarcation of the responsibilities of different authorities, that is the recommendation of the CAG, Lord. With regard to that, they have replied. So far as the specific allegation against
Mr. Mahanti.
Yes, no, Mr. Palit is there. Mr.
GA department here, my lords.
This, how will the lessee take steps? First of all, in 2000, a plot of land is allotted, which is jungle. Kisam is jungle. That first question you have to answer is, how is a jungle kisam land allotted to any party? And then when it is pointed out to you that this is not proper, you say the lessee has been intimated that the lessee should take steps. I've never, there are so many other matters which we come across.
I'll just take your lordship with prayer. Prayer in this writ petition of PIL. This petition styled as a PIL, my lord. The lordship kindly come to the prayer, my lord. That's at page 15. He is raising making specifically two prayers. One is a writ in the nature of mandamus to quash the order dated 26/2/2000 passed by the government of Orissa and the GA department. This is the order of allotment. Is the order
we have crossed all those stages because there's a CAG report. We'll take the CAG report as a starting point. For a PIL, you forget even the petitioner. Once you have a CAG report which points out to you that this is not correct, what has happened, you are asked to explain what is the action taken on the CAG report. All that you have to do is tell us what is the action taken on the CAG report.
Major part of Bhubaneswar, such allotments were there.
Whether there or not, today there is this petition before us for the last 10 years. In these 10 years, the development that has taken place is the CAG report. The CAG report substantiates what the petitioner is saying. Namely, this allotment is not correct because you have made an improper allotment to a party. What is your answer to that?
I'll come with a specific affidavit with regard to that, my lords. Specific affidavit with regard to that.
Our order itself was that. We passed this order in April 21. Which was that? April 21.
Yes, ma'am. That is 12/4/2021.
No, but what you have said in this affidavit, at para 9, just come to this para 9 of this affidavit which we are reading. So for 23 years now, a party is having a jungle kisam land. You have done nothing. And you're saying that the party has to not take steps.
Well, the proposal for
the lessee has been intimated to take steps for filing diversion proposal. This is extraordinary, sir.
Well, what has happened?
What is extraordinary?
Well, this is not a solitary case, Manoj. What has happened?
Whatever it is. No. Once you.
I'll explain, Manoj. What has happened? He's targeting one party. That's all right, Manoj.
It's not targeting, so you can't use this word.
Well,
I'm surprised you're a GA department.
No, I'm same, Manoj, same issue.
same issue in a larger format is pending before the NGT, my lords. In the NGT, my lords, same issue of the entire, not only this.
Why have some other body tell you what you should do, sir? Your GA department.
No, not, my lords, with great respect, my lords, it's not that. The equivalent land has already been identified. Such an affidavit has already been filed before the NGT. Equivalent land of 287 acres have already been identified for.
No, this is not even that much. It's a small plot, I think.
No, this is a part of a larger area. It's a
So it's
this is a part of a larger area. The entire area was taken as a unit, man. The whole area where there are around man, is a major part of in that area. Not only Mayfair, man, there are other government structures, central government and state government buildings which have come up. So for the whole area, we have identified, the state government has identified, the GA department has identified 5 villages. 5 villages with 287 acres, and that has already been segregated for compensatory.
No, but this is
for the requirement. The basic requirement for de-reservation is you give equal land elsewhere. That is, it's not that as if there is a complete bar that forest lands cannot be diverted for any other purpose. It can be diverted, subject to the condition, rather that you have to give equivalent land elsewhere. So that equivalent land elsewhere, it was not Mayfair identified as one proposal. There were several East Coast Railways headquarters is there. There are central government that research institute is there, state government institute is there. The other NALCO office is also there. So it's not that. So we have identified in nearby Chanka Jungle 287 acres, and all that has been forwarded to the MOEF. Now it is pending. It is pending at that stage. That is what I wanted to bring in the shape of an affidavit before your lordship. The recent development. Your lordship calls it next week or week after next month. I'll file the entire picture will be before your lordship. It is not as if that a complete ban. You can't. Diversion can be made subject to equivalent land being forest land being diverted given elsewhere for afforestation. That is the otherwise, the entire most of the capital city of Bhubaneswar will go like this. So that is the reason why, we have identified, I'll file that affidavit, additional affidavit, bring the entire picture before your lordship, And in fact, such an affidavit has been filed. All the details have been given before the NGT. After, the NGT has perused that, NGT has granted time, 6 months to 8 months to complete the entire process. So the entire process is underway.
No. Is this parcel of land part of that NGT?
Yes. This is also part and parcel of that NGT. A comprehensive affidavit has been filed. NGT has already taken up the issue, has disposed of the OA with a direction that you complete the procedure within 6 months. So in fact, lot of development has taken place. And the matter was there before the NGT, maybe week before last, and where we have sought for a little extra time that we'll file further developments. And the proposals are underway.
What my lord
is not that
that is with regard to afforestation and providing of the land equal to the land which has been allotted in the Bhubaneswar city for afforestation. That is that he was placing before your lordship. But what is the question involved in this petition, your lordship kindly see from the CAG report? The allotment itself is illegal. It is not
the same CAG report talks of the other lands also. That's what I'm understanding.
All the lands. Specific.
This is not this alone. A whole lot of other lands, he says.
Well, a lot of other land belongs. So far as this property, the specific property which is involved in this petition, 232 decimals of land, 2001, they have allotted. Till today, there is no lease deed executed. No installment has been paid. And the valuation of the property rocketed high now. That is the government property. The question is whether you have shown the transparency while allotting the government land. It's a costly town like Bhubaneswar. And you are granting the land that has been this CAG has commented, and your lordship by taking note of that CAG report has directed the government what action you have taken. It is not the question of deforestation, my lord. Here the issue is involved whether the lease which has been granted that has relation to the public element and there is reasonableness, and whether you have followed it has fetched the correct market value. No, that is the anxiety. So the Honorable Supreme Court.
Yeah, let's read the paragraph of the CAG report.
Yes, ma'am. The specific paragraph, your lordship can see additional affidavit 2.1.11.3. My additional affidavit here. That is additional affidavit dated 8/9/2014.
Now he's enlarging the scope of the.
No, I am not enlarging. It is a public interest litigation.
His entire allegation was forest land.
The illegality
could not have been allocated. His entire allegation was
permitted to do this
and that land is given as a part
like this fish market value.
Or a playground to these apartment dwellers.
Let at page 22, internal page 22 of that report.
Some market price or some other details.
Para 7, is that what you're trying to draw attention to? Or what is that?
Para 6. I'm just placing the report before your lordship. The GA department at page running page 22 of my additional affidavit. Yes, the GA department allotted 10 acre 237 dispels of land in a prime location. Your lordship got it. The CAG report I have annexed to the additional affidavit.
What's the date of the additional affidavit?
That additional affidavit 8/9/2014. Your lordship also reflected that date in your lordship's order.
Okay. 8/9/2014.
Yes, ma'am.
Oh, I see. All right. Right. Correct.
Yes, ma'am. At running page 22, Milord, of that I have corrected.
Right.
2.1.11.3, thereafter page 22. It starts with the GA department allotted 10 acre 237 acres of land.
Right.
In a prime location of the city, Jayadeva, Bihar, to Mayfair Hotel and Resort Private Limited in 5 phases during March 1998 to February 2000 for construction of hotel building, quarters, mandap, sports complex, etc., as indicated in the table below. These are the lands have been allotted that has been given, the schedule has been given. Scrutiny of records of the department revealed that although the above hotel was already allotted 7 acres of land, by February 99, the lessee again applied in December 1999 for allotment of 3 acre 5 decimals of land for sports complex and 232 decimals of land for construction of staff quarter, despite allotment of 515 decimals of land earlier, February 1999, for the same purpose. The GA department, however, allotted the land requested 3 acre 237 decimals in February 2000. It was noticed that the entire allotment was made within 2 years, with the last phase of allotment 3 acre 237 decimals carried out within 3 months. Further, the land was allotted without obtaining the land use plan and the recommendation of the administrative department as well as SSC. The lessee was allotted the entire 10 acre 237 acres of land, forest some land, without the concurrence of the central government in pursuance to the Forest Conservation Act 1980. Further, the hotel was allowed to pay lease premium in 8 equal half-yearly installments without the approval of the finance department as required. The lessee was also extended undue benefit of 19 lakhs due to charging of lease premium at 1.62 crores against the prevalent market value of the land of 1.81 crores. The department stated January 2013 that the allotment was made for establishment of hotel in a phased manner, considering the entrepreneurial capacity of the allottee. It was also stated that the sum of the allotted land was detected as forest after allotment and the realization of one installment. Further steps were being taken for diversion of this land to non-forest kisam. The reply is not tenable since the department has not defined the ceiling to allot the land for different categories of hotel. So therefore, there is no appropriate premium was fixed. There is no approval from the finance department while fixing the premium. And there is no approval from the government. The GA department, the state officer has allotted this land, 10 acres some odd land in this fashion.
So it's not pertaining only to that 0.232.
Yes.
No, it pertains to the entire 10.237.
Yes, ma'am. I'm entire 2.3 is related to other land also.
No. So this non-concurrence of the central government is in respect of the entire 10.
Entire 10.37 decimals of land.
Whereas
there is no concurrence.
The affidavit now filed makes it appear that the problem is
only in respect of that 232 decimals of land. And that too after 22 years after. (2.1.13.3). What is the conclusion? What is the observation of the CAG in concluding that? It is 2.1.13.3. Land still under encroachment. It was noticed, you got it. It was noticed that even when cases of encroachment were coming to the knowledge of the department, they failed to initiate adequate action to evict the encroacher. It was observed that in the 8 out of 17 test-checked cases of encroachment, though 11.187 acres of land valued 84.21 crores was under the unauthorized possession of 8 encroachers, the department failed to evict them as detailed below. You also can see the Mayfair Hotel in for serial number 3. Jadav Bihar, 3 acre 237 decimals. The total encroachment. At serial number 3. But this is the report submitted by a constitutional authority, and they are sitting over the matter. Now they are coming with an affidavit that in 2021 we have given proposal for diversion. Lord, I am in this position, Lord, I am relying upon two judgments of the Honorable Supreme Court. Lord. That is volume 80, 1980, volume 4 SCC. I did not take your lordship's time. Only paragraph 11 is to suffice me. Only I will place paragraph 11 and a recent judgment.
No, before you do that.
Yes.
This on 3.237.
Yes, ma'am.
So there is already a construction on this 3 acres, obviously. So only 2.232 is vacant.
Yes. 232 is vacant.
The others has already been constructed upon.
Already constructed.
There is a lease deed also.
232 is a sports complex and other things are there.
No, but why do they say it's encroached? Because this was without prior permission.
Prior permission. They have characterized it as encroachment.
It's a jungle-ism which has been
jungle-ism, there is no prior approval, there is no the procedure which are to be
but
followed.
There's also another additional point about the premium.
Yes, ma'am. The premium Miller. And the premium, they have said that is a very low premium.
So these are separate points. This is why when we passed that order and we wanted you to deal with these paragraphs, because it's not just about diversion of jungle land for non-jungle purpose or something. It's much more than that, sir. And this is from information collected from your department. Just see this under the table 12.
Yes.
So what is the purpose of having a CAG if you're not going to read his reports, if you're not going to take action? What's the purpose? CAG is your man. This CAG is doing backbreaking work. And by the time they detect it already, usually 5 years, 10 years, everything is passed. There's a whole army there working, looking into all your records.
That's right.
Somebody has to read it, somebody has to take action.
With regard to this diversion of forest, my lords,
that is only one element, sir. This is the whole point. I think that's why he's pointed out, draw attention to the actual paragraphs. One part of the problem is conversion of jungle land for non-jungle purpose.
That is how, on that premise, probably, my lords, the writ was admitted. Notice was issued on that premise that jungle lands are being allotted.
No, but another problem is you've charged a premium. But the premium is far less than the then market value. We are talking of year 2000.
2000.
And now we are in 2023. I think it's anybody's guess
2000.
What the value is.
It will be pointless.
No, what are you doing to recoup? That is also not. On the other hand, you're now telling us, no, we are going to give alternate land.
No, alternate land for diversion.
For jungle. You're saying we'll find a jungle some 20 kilometers away from the city. Correct?
And with regard to, my lords, I'll just draw your lordship's attention to that paragraph of the.
But what is happening to recover what you've lost in terms monetary value? What have you done for that?
No, with regard to the Rashmi.
Actually, if we start going into it, there are deeper questions.
My lords.
Without a whole set of people approving decisions, this could not have happened.
My lords.
What is the action then taken? Who is made answerable for this? By merely saying, no, there were 10 others, 15 others, 20 others.
The allotment happened in 2000.
Somebody passed a note on the file, somebody approved it.
It was done at the highest level.
Whatever. This level, this is the whole thing, sir.
This was done at the Mallards. With regard to Rashmi Plaza, my lords, your lordships have, this Honorable Court Division Bench has approved this past judgment, my lords, judgment which has been confirmed by the Supreme Court that forest land, my lords, if your lordship just permits me in my affidavit, that affidavit.
No, first of all, sir, Mr. Palit, that your affidavit makes it appear that the entire problem is only in relation to 0.232 decimal. In fact, had we not again read this, we would not have realized that the problem is not just for 0.232 decimal. The problem is actually greater than that, although this report now says the encroachment is 3.237. The earlier paragraph says 10.237 was without approval of the central government. 10.237 was jungle. The CAG report itself reduces 10.237 to 3.237 now.
3.237.
So even for this 3.237, you don't seem to have a reply. You are now reducing this to 0.232.
This one paragraph of that division bench judgment, my lords, of your lordships, which gets confirmed by the Supreme Court, one paragraph, page 45 of my counter affidavit, dated 2/9/2015. Immediately after your lordships issued notice on the writ petition, my lords, the counter affidavit is filed, page 45 of that counter affidavit, one paragraph of the judgment. It is to be noted, this is what your lordships have held, my lords, have delivered in the division bench.
No, where are you reading now? 1 minute.
I am reading the judgment with regard to similar issue with regard to Rashmi Plaza at Cropter. That's one of the 8 pointed out by the CAG report, CAG report. One of the 8 units, my lords, pointed out by the CAG report my learned friend was placing. This is, my lords, in review petition number 99 of 2007. 13/9/2007.
That is also available in that additional affidavit.
My counter affidavit.
That additional affidavit which they have given.
My counter affidavit, my lords.
Review order.
Yes.
Yes. That is available before your lordship in their additional affidavit. They have filed. Affidavit they have filed on page 2021. That is available in page 29.
Can we come to page 44 of that? Paragraph 7.
Another issue.
Page 44, my lord. Your lordship got that page for. I'll take your lordship permission, read together, my lords. Paragraph 7.
1 minute, sir. 1 minute.
You are reading from
paragraph
review petition number
yes.
99 2007.
Grateful.
That is order dated 9/2007.
Month 13/9/2000. Grateful, man. Paragraph 7, page 44.
13/9/2007.
The learned additional government advocate on the query of this court.
546.
My lord, Justice Raman was probably on the right page.
All right. Yes, review petition 99.
The learned additional government advocate on the query of this court has submitted that in question is not the reserve forest but has been recorded as Buddha jungle. We have perused the map of the locality and also the record which shows that the locality has been recorded, the entire locality. Forget, let's forget Mayfair for the time being. The entire locality has been recorded as Buddha jungle. But it is not the case of the state that the same is reserve forest or any forest as existing on the land. We have also observed that part of the land recorded as Buddha jungle in the locality has already been allotted in favor of standard testing laboratory, English language training center, Office of Facor India Limited, Stock Exchange, Satyam Computer Office and Fortune Tower, etc. However, etc. my lords. However, a part of the land recorded as Buddha jungle measuring an area of 8.734 has been allotted to ITCO on 16/12/2005. The buildings of these are existing. Therefore, we do not see any reason as to why the offer made by the state government for allotment of a small portion of land in favor of the instant opposite party, which is lying vacant, should not be available. The restriction of use of land as imposed in Section 2 of the Forest Conservation Act is only applicable in respect of land which has been notified as reserve forest under the State Forest Act or the Central Act. But in the instant case, the land in question has not been notified as reserve forest, nor is general forest, nor in general forest existing over it. Therefore, the provision of Section 2 of the Forest Conservation Act would not at all be applicable in the instant case. So it is to be noticed that in Orissa, especially in Bhubaneswar, which is the capital of the state, a lot of land has been recorded as, well, Lordship was posing.
No, that's right. You finish reading.
A lot of land which has been recorded as Buddha jungle but the government have allotted parts of the land for living purposes, that is residential purposes, as well as for commercial purpose. This is also not disputed that the piece of land offered to the instant opposite party is in the heart of the city where there's already above institutions, offices already existing, and there is structure as well standing, which are adjoining to the land in question, has already been recorded as Buddha jungle, though no jungle is existing there. In view of the above, we do not see any error. This order, my lords, this judgment, my lords, your lordships take judicial cognizance, note of the fact that even though it's recorded as Buddha jungle, my lords, no jungle is standing in the fact. Then next, my lords, page 47. As against this order, the state goes up in appeal to the Supreme Court. Supreme Court, my lords, after hearing it, my lord, dismisses. Third, learned counsel for the petition, delay condon, no merit, special leave applications, dismissed. So therefore, this observation, my lords, gets confirmed. Series of such allotments have been made. So
actually, sir, this entire thing happened. I don't think the CAG report was available at this time, right?
My lords,
CAG report was not available.
My lords.
This is the long and short of it is this.
My lords.
Even Godavarman, all the other orders.
My lords.
There are numerous orders which say that today the land is not a pond.
My lords.
The court
Godavarman said you can't tamper.
The court has never accepted that. The courts have said the ponds have to be revived if it's a pond.
My lords.
If it's Jalasaya, it has to be preserved as Jalasaya. In fact, it has to be revived.
My lords.
That's been the trend everywhere. This is not unique to this state or this city.
My lords.
All over the country, this has happened.
My lords.
And therefore, the courts have drawn a line somewhere saying we can't have this endlessly going on. Because what are we doing? We're presenting a fait accompli. You're saying, listen, there are so many buildings here. Where do you see jungle? Right? The courts have stopped accepting these applications. I mean, these kind of explanations. So this judgment was passed at a time when there was no CAG report. The CAG report points out not just to this problem of conversion of jungle to non-jungle purpose. It points out to a more serious problem. So that you have not dealt with in your order at all, in your affidavit.
19 lakhs, that deficit of 19 lakhs in that.
It's not deficient, sir. I don't know. I want us to explain to you what the problem is. If you don't understand what the problem is, we are prepared to explain to you.
My lord.
Something worth 10 rupees is allotted for 1 rupee. You say, no, the difference is only about 9 rupees. There's no other issue.
It's 10 rupees today on that.
The fact that something which is 10 rupees is allotted for 1 rupee, what does it mean? It's the state doing it. What does it mean? You want us to explain all this? We can explain to you.
No.
You are the GA department. You should know.
No. There was no such, my lords.
This is the CAG telling you, sir. It's not just some busybody petitioner having fanciful ideas.
My lords. I'll, my lords, your lordship permits me, my lords,
So there is a multiplicity of issues here. Don't reduce it to just this issue of jungle kisam.
My lords.
Even this order does not acknowledge the multiplicity of issues. It's projected as if it's only a problem of some jungle land being allotted for non-jungle purposes. No. It's much more serious than that.
My lords, your lordship permits me, I'll file a direct.
There's no permitting, sir. We've been asking you to. This whole problem is, we've been asking you for the last 1 year.
I'll take it upon myself.
Lordship 2021.
Lordship may grant me 10 days time. I'll come up with that affidavit. My lords, what was the benchmark, my lords? I'll produce before your lordship. What was the benchmark?
Very simple, sir. Normally in other cases, we then order an inquiry. We do a fact finding through some independent body. Then we take our decision. Now all those stages are crossed. There's no question of now rediscovering facts.
No, not the question.
Facts have been discovered. Facts have been presented in a report submitted to you by your own CAG. So we are actually asking you, what have you done in relation to the report submitted to you by your own CAG? That's the question we are asking you. So the answer can't be that, this was the market value, I allotted it for this. That is not the answer we are looking from you. We are looking for action taken. What is the meaning of action taken? You know that.
Yes.
The stage for finding out what the truth is, what happened, everything is over. The CAG has done that entire exercise for you.
My lords.
Unless you say, sir, I don't trust my own CAG.
No, that.
And you make bold. You make bold as a GA department to say on affidavit before us, sir, we don't believe our own CAG. Will you say that? I'm serious about this. If you want to say it, if you say, sir, give me time to say, tell before you, we don't trust our CAG, you tell that. I will record it in the order today.
No, that. I don't
If you don't say that,
I don't
if you are bound by what your CAG is telling you, you simply have to tell us what action you have taken.
Action. We have taken action, my lords, for a conversion of the land.
Sir, this is not just about, I don't know, I think I'm going to be endlessly repeating myself.
No,
I don't wish to do that.
I'm not on that, my lords. I'm not on that. I'm not on that, my lords. And we have also stated in the affidavit, my lords, in that the same affidavit, my lords, dated 28/8/2015, your lordship may permit me, my lords.
So you don't deal with these paragraphs at all. This is the problem. You have not dealt with these paragraphs. You've glossed it over. We gave you an opportunity to come clean on this. We'll continue after lunch.
My lords. Area before your lordship on the board, so that your lordship will be able to take a view on this matter. There has been no hanky-panky of any
Not
kind.
for hanky-panky. See, did we ask him to specifically reply to certain paragraphs?
I only seek that opportunity was to file a comprehensive 2 weeks time. Period. Just 2 weeks.
Who is appearing for OP number 5?
I am appearing.
All right.
See, no bad faith involved here, man. No bad faith.
So this is public interest.
Man, absolutely.
Everybody is interested in finding out what the truth is.
Man, I bow down.
All right. You say by an order dated, which was that earlier order?
12/4/2021.
11th April 2021. This court had required the GA department to specifically reply to 12/4/21 to reply to paras 2.1.11.3, 2.1.13.3, and 2.1.13.4 of the report of the Accountant General. No, but the report of the Comptroller and Auditor General of India, bracket CAG. Full stop. In response thereto, an additional affidavit has been filed
on 3/5.
Yeah. Actually, the date here is
21.
3/4.
This 3/4.
2020.
2020.
3/4/2020.
No.
34, sir.
34. I'm sorry.
30th April.
2020.
Yeah, 30th April 2021. by the Deputy Director of Estates in the GA department. First of all, perusal of the said affidavit, it is seen that there is a general response
বিরিয়ানি গরম করে দিল খাইবা তো
to the additional affidavit of the petitioners, along with which the report of the CAG was placed on record, but not specifically to the above paragraphs of the report of the CAG. Paragraph. Mr. Subir Palit, learned counsel appearing for the GA department, seeks one more opportunity for the GA department to respond to the above specific paragraphs of the CAG report. First of the court would like the GA department to explain what action has been taken by the state government in response to the observations contained in the above paragraphs of the CAG report. Stop. The further affidavit of the GA department specific to the above paragraphs of the CAG and spelling out the action taken thereon be filed positively on or before 31st March 2023. List on 5th April. You take back the judgment, you can give it to us.
I'll try. It's a matter fixed for matter fixed for 2 p.m. Item number 58.
My lord, may I submit, my lord? As per direction of the honorable court, the director Ames is present, and
yes,
there is
yes,
a instruction. And as per their instruction, they started the treatment. His regular touch with the director, Center of Excellence. My lord, should I mute it or will be present in the court? Whatever your lordship, he is with me. He'll appear in person if lordship want, or can appear through virtual mode also?
No. Virtual mode is fine, sir. There's no problem with that.
Then open it.
Can the directors unmute? So please unmute.
Yes. Just time.
Dr. Biswas?
Yeah, my lord. Yes, my lord.
Yes. No, did you speak to the counterpart in the Calcutta hospital? Center for Excellence. So 10th March.
Lordship, I have a small submission, Lordship. These kids, all of them have exams going on. So they're specifically requested to not keep in dates in March, either in February or in April, Your Lordship. The date can be changed to April.
They're already in March, so it can't be February.
No, that's what, Lordship. They had specifically requested earlier to keep it in February or in April, but not in March because of the ongoing exams. First week of April, if it's possible, Lordship.
Is that possible, Dr. Biswas?
Yeah, my lord. I am in touch with the director of the Center of Excellence. So, yes, it is possible. We'll reach it.
All right. Dr. Ashutosh Biswas is present online. He has also filed an affidavit in court stating that he had got in touch with the Center of Excellence, that is the IPGMER, Kolkata, and was informed that they have fixed 10th March 2023 for the treatment of the children referred to them by the DMD, the 10 DMD children. You said 10 children suffering from DMD for treatment. Paragraph. Counsel to the petitioner, however, points out that since the annual exams are being conducted in the month of March, the children have requested that the dates of treatment be fixed in April 2023. Paragraph, Dr. Vishwas undertakes to again get in touch with the COE so that the dates for treatment of the children can be fixed during April 2023. He further undertakes that these dates will be informed to the parents of the children over phone within a week from today.
Yes, sir. My lord, we'll call phase wise because it's a very lengthy process to assess.
Yes, yes.
So we'll call phase wise.
All right, sir. All right. That's not a problem.
Lordship, one thing remains from the last order. Is the state was directed
with regard to the instructions, the one-time payment, one-time cash transfer, because we have already moved the government. So, if my lords gives me a week's time,
all right. Mr. Monty has placed before the court the written instructions received from Dr. Ajit Kumar Monty, Special Secretary (PH) to the Government of Odisha in the Health and Family Welfare Department, stating inter alia that the proposal for giving one-time direct financial assistance, independent of any scheme, to the patients suffering from DMD, open quotation, is under active consideration of the government, and expeditious steps are being taken by this department in this regard. The said letter is placed on record. 18th April. We'll call it on 18th April.
Village man.
All right. All right.
You also want to indicate some amount also. This is for children and it's a rare disease.
Correct.
If some amount, your lordship indicate.
No, I think that 6 lakhs was the amount by the government of Bihar.
Fair enough.
Only one. What I'm praying, my lord. This telephone information will be given, as well as they have to cooperate this Center of Exchange as well director of AIMS. That the phase-wise manner, whatever date will be given, they should cooperate. Otherwise, what they are submitting that.
No, they're waiting for this treatment, sir. You can be sure that they will cooperate.
They've never missed a date.
The children, they're desperate. The parents are desperate. All right.
Exam date.
Yeah, only they don't want in March, that's all.
Yes, that's fine.
Great.
Item number 54. May it please, my lords. Pursuant to the last order, there's an affidavit filed with the state dated 3/3/2023. I've gone through that affidavit. My lords, may kindly come to page 5 of that, Annexure D. The second paragraph.
Yes.
The focus of state action plan is to ensure safety and welfare of migrant.
Which affidavit date is this?
3/3/23. This month. 3rd of this month.
Third of March.
3rd of March, it is filed.
It would not have come.
He filed on 3rd of March.
He filed 3/3 or same. Actually, hard copy.
The hard copies are with me. Hard copies.
Yes, sir. Hard copy. It would not have come.
We'd also asked Mr. Padi, is he there? Union of India also to inform, right?
Yes, my lords.
They have not filed any.
They have not filed any.
Mr. Party is not here. He was there just now. I can send someone. Come on.
Annexure D, page 5 of that affidavit. This is the focus of state action plan is to ensure safety and welfare of migrant workers through tracking of migrant workers at Gram Panchayat level by developing a database. When is this database going to be developed? What is the timeline they need to give? Second is convergence of various departments to link migrant workers with welfare schemes of the government for reducing distress migration. Now, let's know, no matter how many steps are taken to prevent, that is not going to work unless there is from the basic grassroots level a concerted effort to give them employment opportunities where they need not migrate. Now, we cannot prevent it entirely, but we can limit that. In that context, there was a counter affidavit filed, my lords, earlier on 15/4/2019. I'll invite my lord's attention to page 337 of that counter affidavit. Yes. Paragraph 22 of page 337 talks about convergence and coordination of different departments. Now, this is a very comprehensive list that the state has come up with. Every single department is mentioned here. Their role in controlling migration of labor to other states has been mentioned. But what has been done pursuant to this? This is the convergence they're talking about. That is nowhere there. So on the drawing board, this is a very good plan, but there is no execution of this plan. If this is properly executed, I think my laws will go a long way towards ameliorating those conditions that exist to force workers to migrate.
And actually, there are some districts from which migration is far more than other districts. In those districts, there has to be awareness created. This whole thing which you are saying, linking them up to the various schemes, there it has to happen. I think Bolangir is one district.
Bolangir is one.
In Khurda district.
They have identified 10 other districts where I believe a survey is being conducted, has been conducted. Let them place that report as soon as possible. The NLS, I think, in association with certain NGOs, has been conducting that survey according to what has been stated in the report.
That survey is going on. Report is awaited.
So I'll pray, my lords, that let them give a timeline for creating this database in point 1 at Annexure D. And then what is the responsibility of each department to take care of welfare schemes, which will limit migration, and to what extent they have actually gone.
Union of India is also not here. Right, an affidavit dated 3rd March 2023 has been filed. By the Additional Labour Commissioner, Odisha, placing on record as Annexure capital D. A note on the activities undertaken from 2021-22 to 2022-23 bracket till February for the safety and welfare of interstate migrant workmen in Odisha. Paragraph. Although it is stated that the focus of the state action plan is A to A. Pointed out by the Vishesh Nayak Learned Amicus Curiae that There is no timeline indicated for completion of some of these steps. Stop. He also draws attention to the action plan earlier placed on record with the counter affidavit of the state government, where in para 22, under the title single quotes, convergence and coordination of different departments, unquote. Specific roles have been assigned to various departments. Full stop. He submits that the state government should be asked to place on record a comprehensive report of the actual outcomes of the implementation of the state action plan. With statistics. Full stop. Paragraph is seen from the affidavit filed. Affidavit dated 3rd March 2023 that a survey on the migrant laborers in Balangir, Bargat, Kalahandi, and Nuapada had earlier been completed and placed on record with an affidavit. Full stop. Whether there has been a further, it further states that it also states that further surveys have been undertaken in collaboration with the National Law University Odisha, bracket NLUO, in 477 migration prone Gram Panchayats, bracket GPs, bracket, in 20 blocks of the above 4 districts. Full stop. The up-to-date status report the updated report on completion of the above surveys be placed on record with an affidavit. Full stop. The court would also like the state government to specify the areas in which specific directions are needed for the proper implementation of the Interstate Migrant Workmen Act. Migrant Workmen bracket RENCS bracket Act 1979. Paragraph. The Union of India was to file an affidavit in terms of the order passed by this court on 16/11/2022 about the steps taken under the Pradhan Mantri Garib Kalyan Yojana, the Pradhan Mantri Jeevan Jyoti Yojana, and the Pradhan Mantri Suraksha Bima Yojana. Full stop. The said affidavit is still awaited. Full stop. The state government and the Union of India will file the respective affidavits in the above.
One more point, if my lords. In paragraph 4 of my lord's order, the specific direction was how the it is directed state government will file a further updated affidavit giving details of the number of beneficiaries whose grievances have been redressed under the state action plan year-wise and how the state action plan has helped in addressing many of the problems assigned highlighted in various reports filed in Supreme Court of India. Therefore, this has not been done.
No,
and there is a year-wise report.
Yeah, year-wise they've not given. They've given an overall numbers.
That year-wise report has to come.
The affidavit of the state government will also specifically comply with the direction issued in para 4 of this court's order dated 16/11/2022. The PIs. 22nd June. My lord.
Item number 55.
May it please your lordship.
As item 55.
Your lordship on the last date had given me a liberty to.
Item 55 before my learned friend begins on the REA. Unless I have placed before my lords an instruction on the latest development with regard
Completion
to the bill.
certificate.
This is with regard to the apartment ownership bill that the government is proposing to enact. My lords, it has already been sent to the Parliamentary Affairs Department for placing the same in the next cabinet meeting. After approval of the cabinet, the bill shall be.
We don't know what the timeline is still.
As the session is still ongoing. It's an ongoing session. The session is still April 6th, my lords. That is the.
So this should happen before 6th April then. Much before actually. You say at the outset, you say, Mr. Mohanty has placed on record. Ishwar Mohanty AC has placed on record a letter dated 3rd March 2023 of the Additional Secretary to the Government in the Housing and Urban Development Department, instructing the Advocate General that the Odisha Apartment Bracket Ownership and Management Bracket Bill 2023 has been sent to the Parliamentary Affairs Department for being placed in the next cabinet meeting. Full stop. After approval of the cabinet, the bill is to be laid on the floor of the assembly. Paragraph. Mr. Mohanty informs the court that the current assembly session ends on April 6th, 2023. Full stop. It is expected that the above bill will be placed before the cabinet and then be laid on the floor of the assembly well before the above date. Yes.
Right. Now I have filed an IA. Your lordship had given me a liberty that if the corrigendum is not carried out in its proper perspective, I can file it. So after that order, your lordship, the sale deeds have commenced illegally and in contravention to your lordship's order and in contravention of the statute. Kindly please let me submit.
I want to intervene.
Your lordship had on 7/12/2022's order, your lordship had noted the contention of the state government that projects which have received completion certificate under section 2Q of the RERA Act by the competent authority under section 2P, those are not falling within the purview of the RERA Act. Then at para 7 of your lordship's order dated 7/12/2022, your lordship held that since section 2Q of the RERA Act implicitly requires reference to section 2P thereof, which defines competent authority, both the provisions have to be read together while interpreting the above word. Now this is not being carried out. I have given an example. After the corrigendum, the sale deed has been executed. Your lordship may kindly turn to page 37 of my IA. Page 37.
IA number?
IA at flag 10, 2276. Page 37, your lordship. Your lordship has got
flag 10.
Yes, your lordship. Flag 10, page 37. The sale date is of 18 January 2023, and the certificate on the basis of which the sale deed has been registered is at page 37. It's completion certificate. It has been given by the concerned builder, one Vipul Limited. Your lordship may see at the bottom who has signed it. It's one Gurendra Kalsi. He is an architect. His residence is at Gurgaon. So now this person is being held to be a competent authority under the RERA Act. And on this basis, all registrations have been going on. Now only, I'll not take more than 5 minutes. Now, what is the definition of competent authority? Now, only your lordship may kindly see the RERA Act. And I'll also place the Odisha Development Authority Act. While keeping this page in front of your lordship,
what's the date of the certificate?
My lord, it is 19/1/2017, prior to RERA Act. At the bottom left-hand corner, my lord.
Oh,
at the bottom left-hand corner.
19/1/2017.
So they say, since this certificate has been issued prior to the RERA Act, I need not comply with the provisions of the RERA Act and registrations can go on. Now, whether this person is a competent authority or not, as per the definition in the RERA Act.
Now, sir, kindly let us not interrupt one. Now, your lordship may kindly see now the definition of a completion certificate under section 2Q. Yes, your lordship. Section 2Q. Completion certificate.
Yes.
2Q, your lordship. Completion certificate means the completion certificate or such other certificate by whatever name called, issued by the competent authority, certifying that the real estate project has been developed according to the sanctioned plan, layout plan, and specification as approved by the competent authority under the local laws. My lord, I'll lay stress on few words. Completion certificate means the completion certificate or such other certificate by whatever name called. Your lordship, now the RERA Act permits to see by what name the certificate issued by the competent authority is called under the local laws. Now your lordship may see section 2P, which is the definition of competent authority, which your lordship had said that it has to be read along with 2Q. Your lordship, 2P I will read. 2P. Competent authority means the local authority or any authority created or established under any law for the time being in force by the appropriate government, which exercises authority over the land under its jurisdiction, this is one part, and has the power to give permission for development of such immovable property. Now there are two conditions to be satisfied for a authority to fall within this definition of competent authority. That is, your lordship, he should exercise authority over the land under his jurisdiction, and he should have the power to give permission for development of such immovable property. Now, my lord, even in the wildest stretch of imagination, this architect, private architect, he doesn't fall under the definition of a competent authority. Absolutely, it doesn't fall. Now, where the confusion arises, your lordship, that is, if I request my learned court master to give the Odisha Development Authority Act, the benefit of which they are trying to take. Section 20, your lordship. Section 20 and section 20 capital A, I will read, your lordship. Yes, my lord. Under section 16, the concerned authority gives permission for construction of a building. Then section 20, every permission granted under this chapter shall remain valid up to a period of 3 years, during which period completion certificate from a registered architect or engineer or a person approved by the authority in the forms prescribed by regulation shall be submitted. And if this is not done, the permissions shall be deemed to be revalidated before the expiration on payment of such fee as may be prescribed. And such revalidation shall be subject to the rules. Now here, this word completion certificate comes in a 1982 Act. Now, my lord, it's not the reverse. Merely because the architect issues a completion certificate here, he will not fall. He doesn't become the competent authority under the RERA Act. The RERA Act confines the definition who can be a competent authority. It's a Central Act, 2017 Act. And
so when he uses Form 6 Part 1, he's referring to the Odisha Development Authorities Act, is it?
Yes.
The architect has given the certificate in Form 6
Yes, your
Part
lordship.
1.
Yes. That is the form under this act, under the BDA rules, this form is there. So the definition of the completion certificate under the RERA Act itself says completion certificate or such other certificate by whatever name called, but it should be issued by the competent authority. Now it is not, sir, I have not finished yet. Sir, so your lordship, it is not the reverse. Merely because the architect is issuing a certificate, he becomes the competent authority under the RERA Act.
May we answer?
1 minute, let him finish, sir. I'm trying to see where this Form 6 is, because the Form 6 in this book is some different form.
I have given a compilation. Just a minute. I have given a compilation of all the provisions.
My lord, that form is
yes
in the BDA rules.
It is in the BDA.
That's 2016 rules.
That is now it's all for the purpose of adjudication of this case. This nomenclature completion certificate that is creating a problem because it was there in the 1982 Act. Now under the RERA Act,
it doesn't create any problem, Miller. Actually, the problem
now
is
under the
that my
RERA
lordship
Act,
trained to interpret it in a proper way.
so
Miller,
that is for your lordship to say.
may permit us to answer. Just a minute.
My friend has,
Now,
my friend has,
Let him finish, sir.
everyone is just trying to. Now, your lordship, the definition of competent of this completion certificate, which I read under the RERA Act, it itself says means the completion certificate or such other certificate by whatever name it may be called. But the ingredient is that it should be issued by the competent authority, as defined under section 2P. 2P says local authority. Now, local authority has also been defined under the RERA Act, which says that the municipal corporation or the municipality or the panchayat, all those things, or any other authority created under the law, then satisfying two conditions. He should have jurisdiction over the land and he should have given permission for development. Now, in the present cases, suppose take, for example, Bhubaneswar. The permission is given by BDA.
Yes.
Yes. Now, neither the architect has a jurisdiction over the land, neither the permission, building construction permission is given by the architect. Everything is done by the BDA. Now it is the BMC. After 2015, BMC is doing. So an architect is not a competent authority, and the certificates issued by them doesn't amount to a completion certificate under section 2Q of the RERA Act.
No, I was trying to find out. He mentions in the certificate on Form 6, Part 1.
Part 1.
So it seems to be in the BDA Planning and Building Standards Regulations.
Regulation, yes, your lord.
2008.
2008.
So, which is not again under the RERA Act.
Yes, your lord. This completion certificate is a misnomer because the Act itself says it may be called by any name, but it should be issued by the competent authority. So now in the state of Odisha, the competent authority, that is the BDA or the BMC, it issues only the occupancy certificate. After this completion certificate is issued, they inspect the building. If everything is in order, they issue the occupancy certificate. So my humble contention is that it is only when that occupancy certificate is issued, a building is complete. And if it is issued prior to commencement of the RERA Act, yes, those buildings will be out of the purview of the RERA Act. But not in this roundabout way where they are trying to override and overreach your lordship's order by showing these certificates by issued by...
Regulation 15 of the BDA regulations.
Yes, your lord.
That talks of completion of construction.
Completion.
And I think regulation 16.
16
for occupancy.
Yes, yes, your lordship. Regulation 16.
(16) is occupancy, 15 is completion.
Correct. 16 is completion of construction. It is 16 subsection 2 will apply here in case of buildings other than low risk building. A completion certificate shall be issued in the as prescribed in the ODA CAF rules, and the same will be submitted by the owner to the authority. So here the builder himself, it is his own architect, he is submitting that yes, my building is complete. Now that doesn't confer him the status of a competent authority under the RERA Act. The Act restricts the definition who can be a competent authority. It's not again the roundabout way that merely because his architect is issuing, he becomes the competent authority.
Yes, what's the state?
Lord, preference of age. Preference of age is mine.
Yes.
Would your lordship see the RERA Act?
Yes.
Lord, kindly take one date. 1/5/2017, RERA Act becomes applicable to the state of Orissa.
Right.
Now, my lord, section 3, if your lordship kindly sees, my lord, page 8.
Yes.
There is a non-obstante clause at 2. Notwithstanding anything contained in subsection 1. My lords have it, my lords. Section 3, subsection 2 of the RERA Act.
Right.
It starts with a non-obstante clause.
Right.
Notwithstanding anything contained in subsection 1, no registration of the real estate project shall be required. Your lordship may straight away come to B, where the promoter has received, kindly note, my lord, it talks about a completion certificate for a real estate project prior to commencement of this act. as opposed to occupancy. So the legislature was very clear. They were enacting the RERA Act. In the RERA Act, they had defined what is occupancy, what is completion. They chose to say that under 3(2)(b), if you have a completion certificate, it is good enough. Now, we are all dealing here with cases where the completion certificate has come prior to 1/5/2017. So it is not a case of a completion certificate post the RERA Act. And this drew the attention of my lord, the Supreme Court, my lord, in New Text case, which was delivered, a judgment was delivered on 11th of November 2021. Would your lordships have that judgment for a minute? So once we clear the distinction between occupancy and completion, the matter ends. Your lordship may kindly see, my lord, page 11. I am handing over the judgment. Para 54. My lords may kindly turn to page 11 minutes. This is a new take.
Yes.
Lordships have 54 minutes.
Yes.
From the scheme of the Act of 2016, its application is retroactive in character, and it can safely be observed. The projects already completed, your lordship may kindly note the word, my lord, projects already completed or to which the completion certificate has been granted. They say not only a completion certificate, but if it is a project which is completed or to which the completion certificate has been granted are not under its fold and therefore vested or accrued rights, if any, in no manner shall affected. So the submission to your lordship is now kindly look at the prayer, page 9 of this IA. The confusion has arisen because of this. The prayer says, my lords, and be further pleased to direct. My lordships have the prayer, my lord? Page 9 of the IA.
Yes.
And be further pleased to direct that in respect of the state of Orissa, the projects which have not received completion certificate from the competent authority, that is, have not received occupancy certificate before 1/5/17, that is the date of implementation of the RERA Act, shall be treated as ongoing project. That is completely wrong. Because the Act says that anything prior to this Act, it will be a completion certificate. The legislature was conscious of occupancy certificate, but they chose under 3(2)(b) to say it is a completion certificate. So therefore, millards, what he wants to now say is, under 3(2)(b), the promoter has received completion certificate should be read as the promoter has received a occupancy certificate.
No. I think what he's saying is the expression completion certificate.
Yes, millards.
You have to go by the definition of this Act.
Obviously, millards, post 2017, post 1/5/2017, this Act would come into play. So the completion certificate, occupancy certificate under this Act, on and after 1/5/27 has to be only under this Act. What he is saying is that you have to now look back to a period prior in time of 1/5/27, and then whatever may have been the process of getting a completion certificate, RERA has to be read into that. That's not the intention of the legislature.
No, let's.
The legislature says otherwise.
1 minute.
Yes, millards.
Admittedly, this particular sale deed that he's talking of,
yes,
was registered after the Act came into force.
Fair enough, millards. The question is.
No, 1 minute.
Yes.
Now, when you look at this 3(2)(b),
yes, millards,
when it uses the expression completion certificate,
lordship pleases,
it has to be interpreted as per the RERA Act.
So therefore, my lord, what it says is, where RERA Act does not apply, you kindly see what is 3. Prior registration of real estate project with RERA authority. So therefore, it says if a project has not been completed prior to the commencement of the RERA Act, then this Act will apply. Milord, may I read 3(2)(b) again?
Yes.
Notwithstanding anything contained in this subsection, no registration of the real estate project shall be required. So this Act is not required to be followed under certain exceptions. And what is that exception carved out in B? The exception is where the promoter has received completion certificate for a real estate project prior to commencement of this act. So therefore, if your building has a completion certificate prior to 1/5/2017, this act has no application. And that is what New Tech held. New Tech went a step further. It said completed or has a completion certificate. It said both. So therefore, 2017 RERA Act will only apply to cases where completion certificate is not there. Take for example, my lord, I have an apartment in 2014 and I want to sell it. RERA has nothing to do with that. RERA will only kick in if you do not have a completion certificate by 1/5/2017. As your lordship, now I will show you what is a completion certificate. Kindly see the ODA rules, ODA Act.
Yes.
Yes, ma'am. Kindly see section 20. RERA Act was not in contemplation when all this was happening. Your lordship may see section 20. My lords have 20.
Yes.
Every permission granted under this act, under this chapter, shall remain valid up to 3 years, during which period completion certificate from whom, my lords? From a registered architect or engineer or a person approved by the authority in the forms prescribed by the regulation shall be submitted, and of this is not done, etc., etc. So who will give it? It will be either by a completion certificate by a registered architect or by an engineer or a person approved. Now kindly look at the rules. The VDA rules.
That's that form 6.
Lordship, please. I'll show you, lordship, the rule minutes. Hand over copies.
What is that? This is my book.
Lord, kindly see. Kindly see, my lords. Page 3 is authority. My lordships have it, my lords?
Yes.
214 means Bhubaneswar Development Authority and does not include its employees and acting individually. The powers and responsibility of the authority under this regulation cannot be delegated unless specifically provided for in this regulation. So we have to now see what this regulation provides. Would your lordships then kindly turn to, my lords, page 12, rule 102, 2102. Who is a registered architect? My lordships have it, my lords?
Yes.
Registered architect means an architect registered with the Council of Architecture who is not in areas of subscription and has not been debarred by the authority. Now kindly see, my lords, rule 67. 67 at page 70. My lordships have it, my lords. Page 70. Every applicant / owner,
yes,
shall submit in notice form 6, which your lordship saw, my lords, part 1 and 2, regarding completion of the construction of a multi-storied building to the authority through the registered architect, structural engineer who has supervised the construction. So the rule as it then existed said that every applicant and owner shall submit a notice in form 6, part 1 and part 2 regarding completion of the construction. Now kindly see form 6, my lords. Your lordships will get it at, my lord, page 149.
Yes.
My lords have it, my lords?
Yes.
Form 6, part 1, completion certificate from so-and-so to so-and-so. I hereby certify the development of erection, re-erection or material alterations in respect of so-and-so, so-and-so, municipal corporation, municipality, NSA within the development area of so-and-so has been supervised by me and has been completed on so and so according to the plan sanctioned by dated so and so. So the completion certificate as envisaged prior to RERA, prior into coming into force of RERA in 15 was this completion certificate. And section 3(2)(b) clearly refers to only this completion certificate. Below 23, when RERA Act was enacted, the Parliament was conscious that there is a concept of a completion certificate. There is also a concept of occupancy certificate. And in 3(2)(b), it did not use the word occupancy certificate. It used the expression completion certificate. Now, in the IA, my learned friend says, is some architect is, of course, some architect will do it. That is what the rules prescribe. It can't be some architect. The architect is a professional course and is an empaneled architect. And if your lordship sees the certificate which has been issued,
it's 37.
Page 37. If your lordship sees, my lord, left-hand side, this is some Gurinder Kalsi, BARC MCA, registration number so and so, signature empaneled technical person. So he has been empaneled under the rules. My lord, in the petition also, if your lordships will see, one FAQ has been enclosed. Kindly see, my lord, to say that this is contrary to what the RERA says, and that is at page 18 of that IA. 11, no? My lords may see, have page 18, my lords?
Yes.
This is a FAQ by the RERA. This has also been relied upon. Completion certificate / occupancy certificate. And this was issued in 2018. And what it says, my lords? It says that the RE and RD Act 2016 recognizes certificate by the competent authority which exercise authority over the land under its jurisdiction and has powers and permission to give permissions for so and so. Hence, only occupancy certificate. So he says the RERA guidelines say, FAQ says occupancy certificate. Now I'll tell you, lordships, what triggered this present IA. There are two orders of the RERA. One of the appellate authority order, your lordship may kindly have it. This very question was brought to the attention of RERA, the appellate authority. The very same question, whether it is occupancy certificate or it is the completion certificate. A complaint was filed, and this is an order of 4th of January 2023, and this IA was filed immediately thereafter. On 20th of January, February, this IA was filed. Kindly turn to page 4, my lord. The completion, my lords have it, my lords?
Yes.
Page 4.
Yes, yes.
The completion certificate of phase 1 has been issued by the technical person on 29/2/16. Kindly note the date, my lord, 29/2/16. And the occupancy certificate and so and so, which are marked as so and so. On the face of such document and the position of law, there is nothing to doubt that the project under phase 1 was completed prior to 1/5/2017 when the Act came into force. The Honorable Apex Court of India, in the case of New Tech Promoters and Developers Private Limited versus so and so and others, have held that projects already completed or to which completion certificate has been granted prior to commencement of the Act are not under the fold of the Real Estate Regulation Development Act 2016. Again, section 3(2)(b) of the Odisha Real Estate Regulation Act ORERA 2016 envisages that where a promoter has received completion certificate for a real estate project prior to commencement of this Act, the registration of the real estate project will not be required in such circumstances. The learned authority will skip all that. So therefore, my lords, section 3(2)(b) is very clear. It talks of a completion certificate. New Tech re-emphasizes it. And therefore, after RERA has come into force, that is 1/5/2017, all the requirements of RERA are required to be followed. So in my humble submission, this petition is wholly misconceived. If my learned friend wants to have the relief, then what he's seeking, your lordships, is to say that the expression completion certificate under 3(2)(b) has to be now read as an occupancy certificate. That's not the intention of the legislature.
All right.
Well, I'm deeply obliged.
May I add a few points, Mira?
Yes.
Two things. If your lordship would look at the RERA Act again.
Yes.
Let this section 2H.
Yes.
Let that the definition of architect, not that either an architect or an engineer, they are strangers to the statute. But architect means a person registered as an architect under the provisions of the Architect Act 1972. It's a recognized authority under RERA also. And the engineer, your lordship would find a definition in U, 2U. Engineer means a person who possesses a bachelor's degree or equivalent form from an institution recognized by the All India Council of Technical Education or any university or any institution recognized under a law or is registered as an engineer under any law for the time being in force. Let this Development Authorities Act 1982 is an existing law which was governing the field. So far, the regulation, construction, grant of permission, grant of completion certificate and occupancy certificate, whatever may be, are concerned. Let section 88, your lordship may kindly turn to RERA Act. Let the RERA, it is in addition to, not in derogation of the existing laws. Your lordship knows that clause that has come for section 88, Mila. Let it doesn't take away the effect of the existing laws. Section 88 of the Act. Let that is why 88.
Yes.
Let 1 second. Application of other laws not barred. The provisions of these acts shall be in addition to and not in derogation of the provisions of any other law for the time being in force. So, my lord, section 20 of the ODA Act has to be given effect to. Not that it is not impliedly overruled or, my lord, repealed by enactment of the RERA Act. So, section 20, my lord, so far it applies to the old buildings or the apartments, etc., my lord, which were regulated as per the 1982 Act and the rules framed thereunder. My lord, they would govern that. So, the contention of my learned friend that the architect is a stranger, the engineer is a stranger, so therefore they are not, my lord, possibly entitled to grant the completion certificate is rather a misnomer. He poses the question and answers also, my lord. The question, so far it refers to 3(2)(b), it refers to only completion certificate. Completion certificate, my lord, as required under law, my lord, is to be granted under section 20 of the ODA Act. My lord, at the cost of repetition, may I again read section 20? Read not, with the, not necessary, sir. The same thing that has also been reiterated in the Orissa Development Authorities Common Application Form Rules 2016, my lord. That I have given a compilation. Completion certificate means a certificate issued under section 20, my lord. Your lordship may kindly, I have given a compilation of all the provisions, the ODA Act, the rules, and the firm relevant form, the RERA Act, all those forms. Occupancy certificate, my lord, 2J, that is, my lord, not connected with this ongoing project. That ongoing project has not, my lord, admittedly defined in the RERA Act. Rather, they say a real estate project. Ongoing project, my lord, would be treated in respect of a particular apartment which has not received the completion certificate. Completion certificate, my lord, my learned friend wants to create a confusion by, my lord, mixing these two interpretations, 2P and Q. Obviously, my lord, it has reference under the RERA Act. So far, my lord, the interpretation under RERA Act is concerned, 2P and 2Q are to be read conjointly because, my lord, the projects which are required to be registered after the commencement of the RERA Act. My lord, this exception which has been carved out under section 3(2)(b) is, my lord, very clear. That doesn't say that a completion certificate required to be issued by a competent authority. Competent authority means, my lord, the authority which is authorized under the ODA Act. My lord, your lordship may comprehend the definition here, competent authority. Obviously, my lord, refers to the authority empowered under the ODA Act to grant the completion certificate. My lord, that empowered authority or competent, whatever expression may be given to it, is the architect or the engineer or the authority.
No, I think the Advocate General's argument is slightly different.
That's correct.
No, slightly different from what you're arguing. His point was,
I think in my understanding.
No, his point was once 3(2)(b) makes it clear that there is no registration required under this act at all.
Yes.
Then the question of referring to the completion certificate
That's
as
correct,
defined in the act does not arise.
That's correct.
Ah.
No, it is not for,
No, you can't.
only for
So
a
there's no
project,
need
my
for
lord.
us to interpret that the expression completion certificate under the RERA Act.
Lordship may kindly, yes, everything he wants to bring within the fold of RERA Act.
Anyway,
As thing, Lord, RERA is the gospel, and that is the Bible, and everything, all those structures, constructions which were there, it is to be brought under the purview of RERA Act.
All right.
My lord, may
Not necessary, sir. Let him reply. Let him reply, sir.
I'll just wrap it up in
Yes.
just cite that new tech. There are few more paragraphs. Just only new tech. My lord, may kindly see. The judgment which was given. My lord, may kindly see new tech, paragraph 6. Only the paragraphs which are not shown. Para 6, object over the past 2 decades. With the growth, this, my lord, may kindly take note. They have said that why this act came into force. Then, my lords, may kindly see para 15. They have analyzed the sections. Chapter 2. I hope my lord has the SCC version.
Yes, yes.
Chapter 2 of the act relates to the registration of real estate projects. Section 3 mandates prior registration of real estate projects, including ongoing projects, with the Real Estate Regulatory Authority. Section 4 prescribes for ingredients of application. So here, these sections have been analyzed. Then, my lord, may kindly see what is the most important here would be para 31. The questions which fell before the Supreme Court. Para 31. After we have heard learned counsel for the parties at length, the following questions emerges for our consideration in the present batch of appeals as under. Question number 1, my lords, would be important. Whether the Act 2016 is retrospective or retroactive in its operation, and what will be its legal consequence if tested on the anvil of the Constitution of India. Then, my lords, may kindly see para 33. Under Chapter 2 of the Act 2016, registration of real estate projects became mandatory, and to make the statute applicable and to take its place under subsection 1 of section 3, it was made statutory that without registering the real estate project with the Real Estate Regulatory Authority established under the Act, no promoter shall advertise, market so and so, as the case may be in real estate project, but with the aid of proviso of subsection 3(1), it was mandated that such projects which are ongoing on the date of commencement of the Act, and more specifically, the projects to which the completion certificate has not been issued, such promoters shall be under obligation to make an application to the authority for the registration and the said project within a period of 3 months from the date of commencement of the Act, with certain exemptions being granted to such of the projects covered by subsection 2 of section 3 of the Act. As a consequence, all such home buyers agreements which has been executed by the parties inter se has to abide by the legislative mandate in completion of their ongoing project so and so. Para 34, the term ongoing project has not been defined under the Act, while the expression real estate project is defined under 2ZN of the Act, which reads as under. Then, my lords, may kindly see para 35. The Act is intended to comply even to ongoing real estate project. The expression ongoing has been defined under Rule 2H of the Uttar Pradesh Real Estate so and so, and they have their clause 3 would be important, where all developmental work has been completed and sale so and so, 60% of the apartment houses have been executed. So, my lords, here, my lords, may pause for a moment. Now, what this judgment basically says, that you can accommodate the local law which is governing the field prior to the commencement of the RERA Act. Now, here the local law under section 20 and the building regulations, they visualize a completion certificate by the architect. Now, if my lords, if I take my lords to the prayer in the present PIL, it doesn't concern either the vires of section 20 or any of the other building regulations. This is only vis-a-vis for allottees, formation of allottees, association of allottees. If my lord would see the prayer, it's not related to any of the other provisions. So that would be probably going beyond what the PIL is about. Now, this point had been argued by my friend twice. In fact, by this live streaming, we are able to see what he had said. 2 videos also I have seen. These very same points were raised again, and this was actually dealt with by my lord's order in December.
where this was basically said that these individual issues can be taken up on a case-to-case basis by whichever competent forum is. So this is, my lords, his third attempt to revisit this entire issue, which was actually set at rest by the clarification by the IGM. So now, my lords, after this new tech judgment, where they have categorically said, my lords may kindly see thereafter, 36 says that completion certificate is the be all and end all. Then para 37 is very important, where they have analyzed section 3. And if my lords would see para 52.
Yeah.
The Parliament intended to bring within its fold of the statute the ongoing real estate projects in its wide amplitude used by the term converting an existing building or a part thereof into apartments, including every kind of developmental activity, either existing or upcoming in future under section 3 of the Act. The intention of the legislature by necessary implication and without any ambiguity is to include those projects which are ongoing and in cases where completion certificate has not been issued within its fold. So after this, my lords, these issues cannot be revisited now in this manner. In this PIL, my lords.
My learned senior skipped the last word, which is most important, para 52. Your lordship. Sir, kindly, we are on para 52, so I am just placing it.
Para 52.
Your lordship may see the in last line, the intention of the legislature by
this not fair.
The intention of the legislature by necessary implication and without any ambiguity is to include those projects which were ongoing and in cases where completion certificate has not been issued within the fold of the Act, within the fold of the RERA Act. Now they are importing the definition of ODA Act and saying,
one
statute which is not there.
1 minute, please. See, the question really is this. This project was completed prior to the coming into force of the RERA Act. Right? This project was not incomplete. It was not an ongoing project. Right? It was a completed project, completed prior to the coming into force of the RERA Act. And a completion certificate was issued on 19th January.
Before the effective
19th January 2017. So it's very clear that if you look at 2PQ, that section 3, sorry.
32B. It shall not be required where the promoter.
Sir, please. Sir. No registration shall be required. See, the word if it had preceded completion certificate, would have been even better. So this is poor drafting, actually.
Where the promoter has received completion.
A completion. If they said a completion certificate, that would have been ideal. That should be the correct way of drafting this. Instead of they simply said completion certificate. So when they use the word completion certificate here, we can't go back to this Act because this Act does not require registration at all. It's as if this Act doesn't apply.
Yes.
So once this Act does not apply, for the expression completion certificate, you have to go to the existing law.
My humble submission is that as in this held in this new tech Act, to interpret completion certificate under the provisions of the Act, we have to fall back upon the definition.
No. That's not what this is.
As provided under the Act.
No. Just let's look at para 52.
Para 52.
Yes.
The Parliament intended to bring within the fold of the statute the ongoing real estate project in its wide amplitude.
Yes.
Use the term converting an existing building or a part thereof into apartments, including every kind of developmental activity, either existing or upcoming in future, under section 3(1) of the Act. The intention of the legislature by necessary implication.
Not that issued is not within the fold of the Act.
Issued within the fold.
No. Bring the projects within the fold of the Act. Where is to include those projects within the fold of the Act.
Yes.
Not about the completion certificate issued.
Let's read.
Yes. This is English.
Yes. It is to include those projects which were ongoing.
Actually, if you put a word comma there, that's what it means. Up to issued, then within the fold of the Act.
Issued,
comma, within the fold of the Act. So bringing the ongoing projects within the fold of the Act.
Yes, it is to include those projects which were ongoing and in cases where completion certificate has not been issued.
So it's not that the completion certificate has to be issued in the fold of the Act, within the Act.
The projects are brought within the act. Which projects are brought within the act? Which were ongoing and cases where completion certificate.
Yes. So, my lord,
it's only English ultimately.
That's good.
So your lordship may see this project was within the fold of the RERA Act.
Yeah, that's
my lord, this project which example which I am showing, it was within the fold of the RERA Act. There is a certificate. At page 45, your lordship may see just page 45 of this my IA.
1 minute.
Of this IA. It's a registered project under the RERA Act. And they are saying it doesn't require registration. It's a total confusion going on. This particular project is registered on 3/2/2018.
1 minute.
My lord, page 45, annexure 8.
Annexure 8.
8, page 45, your lordship.
My lord, may
now your lordship may see clause 1, subclause 2. The promoter shall execute and register a conveyance deed in favor of the allottee or the association of the allottees, as the case may be, of the apartment plot.
So they've granted registration under the RERA Act?
Yes. Because it requires registration. And the sale deeds have been registered contrary to this clause, where there is no association.
So this is what they need to explain then. Let's hear the RERA now.
Just the explanation to 3(2)(b).
And this
I know, but the RERA has gone and
what the explanation says is, your lordship knows, my lord, these are from towers to towers. Kindly see the explanation. For the purposes of this section, where the real estate project is to be developed in phases, every such phase shall be considered as a standalone.
No, but this Vipul Gardens, is it in phases?
Yes. If your lordship see, just give me a minute, please. Would your lordship see his IA again? Would your lordship see his IA again, my lords? His own IA, and kindly look at the completion certificate. At page 37, my lords, have it, my lords? Page 37 of the IA. My lordships have it, my lords? That Roman 6 form.
Which page is that?
Page 37 of the IA. 37. Let me read this. I hereby certify that development of erection of the buildings on plot number so-and-so, khata number so-and-so, has been completed for tower number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 and basement number so-and-so. So these are different towers. And below today, one memo has been filed by the BDA, from where your lordships will see that phases 1 and 2, 1 and 8, to which this apartment belongs, it was completed. I'm sorry, Milord.
They're giving.
Yes, Milord, this 1 to 8, tower 1 and 8 were completed, Milords, as early as 4th of February 2013. So these are, even the RERA Act, my lords, under the explanation says that there can be different phases.
No, but this registration certificate, you come to that now.
Could be. Vipul is not before us. Vipul could be doing more projects.
No. This RERA authority has to explain to us.
Yes.
Just if you come to that page 45.
Correct, 49 minutes. That my learned friend was reading.
Annexure 8, sir.
45, I'm sorry, lordship is right.
Registration is granted.
Yes.
To the following project, right? And it simply says Vipul Gardens.
No, Vipul Gardens Limited, rectangle 1.
No, that's the address, sir.
Yeah.
The project is Vipul Gardens.
So, my lord, they must have to tell your lordships, was it in really these phases or new phase?
I have annexed the plan. It is not in phase. Your lordship, page 39. The plan approved by the BDA. Your lordship may see page 39. From the top, A, B, C. Construction of a basement plus 10 blocks of G plus 14 storage building. This is the plan, and accordingly, this is the completion certificate and the RERA registration certificate. This project doesn't have an occupancy certificate till date. People are residing there. Electricity, water connection, everything. No RERA norms followed. No association. Even this doesn't have a fire safety certificate under the Orissa fire safety rules.
Actually, Mr. Parija.
Yes, my lord.
If the RERA Act, according to you, never applied,
my lord,
Where's the question of such a certificate being issued?
Your Lordship, because RERA Act is not applicable.
Then there's a question of
We'll have to
registration
check,
certificate.
One
sir.
has to check, my lords. RERA has to tell us why the certificate
So
was
let the
issued.
RERA tell us. Yes.
I'll find out. I'll take instructional. My lord, it was
Back
served,
to square one.
it was served
After all
long,
these arguments.
it was served long back.
My lord, the point is, if my learned friend is on a fishing inquiry,
No.
the point is,
Mr. Parila,
people should have been made a party, my lords.
Lord, it's not a
People should have been made a
Let
party.
us explain. Forget Vipul being made a party. RERA.
Explain to your lordship.
Milord, Milord, may I submit one sentence? Milord, your lordship may kindly permit me this clarify. The pool may be a standalone project. Milord, all the registrations in respect of other completed projects, Milord, my learned friend, Milord, the intends to stall every registration in the state. I mean, that is in fact creating problem for many buyers, sellers, everything. Whole lot of Milord, purchase and sale.
Whom are you appearing, sir, for?
Milord,
Are you appearing for a project which was completed prior to?
Yes, Milord, I am for the association, whole association.
No.
Milord, your
One minute,
lordship may
sir.
kindly-
1 minute. Which is this project you're appearing for? Whom are you appearing for? First of all, let us be clear.
I am appearing for a collective body, a registered body, the association of all the promoters of the state. Lord, maybe
All right.
people, whether your lordship may kindly appreciate. It is a question of pre-RERA and post-RERA.
1 minute, sir. Let us first now deal with this one thing.
you
We'll
lordship
come to the
may
larger question.
deal with
Every time, sir, the problem is this. The problem lies somewhere else. All of you are trying to explain what the RERA is doing. Let the RERA explain what it is doing, sir. Why are you people explaining?
No, Milord, because we are stakeholders, your lordship may.
The problem, sir, the person who's doing all this is not answering.
No, that is
everybody else is answering.
No, that is your lordship.
So let us ask RERA why it is doing what it is doing.
So that is in respect of maybe Vipul. Milord, all the.
Sir, right now, this application, we are dealing with this Vipul, whatever this registration granted, let them explain. Yes.
I'll file an affidavit with regard to that matter.
Say this IA number 2276 of 2023. Although it has been argued by the learned Advocate General that in respect of projects completed on the strength of the judgment New Tech Promoters and Developers Private Limited was the state of UP 2021 SEC Online SC 1044 that under section 2 bracket surface 3 bracket 2 bracket small b of the Real Estate Regulation Development Act 2016 bracket RERA Act, no registration of a project that in respect of which a completion certificate was issued prior to coming into force of the RERA Act on 1st May 2017 is necessary. The court finds that in respect of the project, single quotes, Vipul Gardens, unquote, such a registration certificate has in fact been issued in Form B by the Odisha Real Estate Regulatory Authority, bracket ORERA, on 3rd February 2018. Paragraph. Faced with such an anomaly, Mr. Tripathi, learned counsel appearing for ORERA, states that he will file an affidavit explaining how such a certificate was in fact issued. The affidavit will be filed within 2 weeks with an advance copy to counsel for the other parties. Is there another date for the matter already? 22nd March.
In fact, I have also given another. I had also given another example in my previous affidavit dated 2nd of December 22, where
once they explain how they're doing it, then it
because
clear.
all projects are taking it. I'll explain that in another year.
Right.
Now, Your Lordship, there is also a contempt petition here. Now, Your Lordship had allowed the registration of agreement for sale, and Your Lordship had held that the amended agreement for sale which came up, the government and the authorities will strictly abide by it. Now, what Your Lordship is happening, I have annexed one agreement for sale. Your Lordship may just kindly see.
1 minute.
My Lord, it is contempt number 400 of 2023, Your Lordship. Your Lordship, this is one agreement for sale registered on 9th of December 2022. It starts from page 28. Right. My lord, may come to page 54, clause 18. Then I will also show what was the, should I first show what is the existing clause 18? Your Lordship, only I'll just refer to page 25 only once to trouble your Lordship. What is clause 18? This is on
25.
Page 25. This is the revised format which came.
Right.
T. Clause 18. The promoter undertakes that it has no right to make additions or put up additional structure anywhere in the project after the building plan, layout plan, sanction plan, specification, amenities and facilities have been approved by the competent authorities and disclosed except as provided in the Act. Now this should be clause 18. Now your Lordship may see page 54. This is one agreement for sale. Your Lordship, I'll read it. Page 54, clause 18.
Yes.
I'll read. Promoter area, it says. Given the size of Z1 project and the development of the same in multiple phases, club, swimming pool, banquet, restaurant, lounge, cafeteria, dormitory, common hall, all, your Lordship, all those things are there, meditation area, physiotherapy area, which is not allocated or delineated to any specific phase. The promoter area will be available for use on payment basis as decided by the promoter or facilitation management company for the use and benefit of all the resident owners, occupants of different phase, and will be outside the line delineated for the project. The promoter shall in its discretion have the sole right to change, modify, repair, upgrade, rename, relocate any part of the promoter area.
The opposite.
And the allottee, your Lordship, furthermore, surprising things are there. And the allottee agrees and undertakes that they have no right and consequently no objection to the same whatsoever. Now, the promoter shall at its sole discretion have the right to allot, alienate, assign or sell any of the promoter area to anyone of their choice, for which the allottee agrees.
What's the date of this agreement?
My Lord, 9th December 2022.
That's after this amendment.
After this amendment. This amendment, your Lordship, is at page 21.
Please, you notice, it's a notice for the IGR.
IGR and the sub-registrar.
You'll accept for both of them.
After this, hundreds of similar agreements have been done.
Affidavits will be filed by both opposite parties 1 and 2, explaining how the agreement for sale dated 9/12/2022, bracket Annexure 6, was registered, which prima facie appears to be contrary to the amendment to the real estate amendment. Contrary to the amendment.
Page 21, Odisha Real Estate.
Yeah, that is the Odisha Real Estate Bracket Regulation and Development Amendment Rules 2022, notified on 12 September 2022, bracket Annexure 4. The affidavits be filed within a week. Both the opposite parties shall remain present in virtual mode on the next date, same date. All right.
Your Lordship posted to 22nd March. So, let the actually, let one more. Let the framing of law, your Lordship knows how does it.
In fact,
your Lordship, no, this is a learning experience.
No, that's correct. So, wherever exigency arises, they promulgate it. Your Lordship knows that it may take hardly 3-4 hours to make a law. So, no bill, no such bill is pending before the House as of now. So,
they're not saying it is pending.
No, that goes to cabinet. Cabinet may approve, may disapprove. What is Millard? Since 2020, such a bill is moving here and there. I do not know what is the final outcome of that bill. But that amendment was...
No, you put something in your mouth, you keep chewing. You have to finally swallow it.
2020 something was mooted, and there is already an apartment ownership rule of 1982, Millard. But maybe there is some conflicting provision. I don't, but that is in addition to I SOT section 18.
Sir, the long and short of this, if you want to find a solution, you will find a solution.
That's correct. So, but let
March is what your Lordship said.
Bar, Millard, but let the framing of law, Millard, should not stand on the way of interpretation of all those existing laws. But that is how your lordship have to decide the pending application. Let them frame a law. Nobody prevents the legislature to come out with a new law that may be also beneficial for the stakeholders.
Correct.
So that is not our, everybody, your lordship knows black ships are there everywhere. Not that every stock and barrel should be put in that particular pattern. That is everywhere.
May I also disturb for a minute, my lord, kindly pardon me. So far, this particular writ application is concerned, I have been served a miscase matters 2 days, 3 days before. But I have BD has not been made a party to that writ. I have not received a copy of the writ petition. What is there?
No, actually, you just connected parties.
The soft copy. But he's
I'm ready to take soft copy.
If he's made a party, then something follows.
Something follows that minors understand.
All right, you take a soft copy, so no problem.
I'm not a party there also.
Right.
On the next turn, I'll just argue one small point. I also filed that judgment of the Honorable Supreme Court regarding this repugnancy between state law and the RERA Act. Honorable Justice D.Y. Chandrachud's judgment, recent judgment is there, where it says of implied repeal under Article 254 of the Constitution.
So RERA will prevail.
Yes. Whatever things contrary to
law,
contrary are there under the state law.
Of law.
Provided, there is a conflict. Everybody knows that it says
the state laws can only occupy the spaces which are left by the RERA Act. This is the language.
That's already occupied.
That I will.
There is no apparent conflict.
Let's keep all this for the next date.
If the new act comes, then we won't trouble your lordship.
So whether the fields are occupied or not, we will definitely be occupied.
No, blessed.
All right.
We are great.
I don't know, 56.
It may please your lordship. My lord,
50.
lordship kindly say there is the report of the collector, my lord. At Clark X.
I'm appearing for the opposite party 5, your lordship. May I submit something that is important in this case, your lordship?
Yeah.
Lordship, this writ petition was filed challenging the appointment of opposite number 5 as the president of the governing body. It's a government order appointment at Annex 2 of the writ petition, your lordship. What has transpired in the meanwhile, lordship, on 7th February 2023, he has retired from the said post.
Retired?
He's retired, your lordship. I have a copy of the resignation. Resigned, I'm sorry. I apologize.
Therefore, he is not a government servant.
No, he's not a service lawyer.
He's resigned, your lordship.
Mr. Mohanty is steeped in that, so he's very sharp. He knows what is retired, what is resigned.
Resigned, my lord. If he resigns, he has resigned, my lord, that it becomes infraction.
Correct.
That your lordship
will record a statement.
Yes, your lordship.
What collector has written, my lord, your lordship can see that report. What he has written. That flag X, my lord. I do not know that what is what.
Is there a report in seal cover or what?
There. At flag X, the report of the collector is there. It has been mentioned in the cause title, my lord. I do not know whether
he says he has no comment.
No comment.
It's just like a counter affidavit is fine. I don't know what he's understood.
Paravis reply.
As my lord, it becomes infructuous, my lord. Then you'll also make it record the statement of my learned friend and make it.
The court is informed by Mr. So-and-so that opposite party number 5 has resigned from the post.
Yes.
As president of the governing body of the Upendranath Degree College with effect from 5th February.
7th February.
7th February 2023. In the view of the matter, the present petition has been rendered infructuous and is disposed of as such.
All right. Deeply good.
All right.
I don't know, 57.
Lord. In this PIL, my lord, there are 8 opposite parties. Now, out of 8, only 4 have filed their counter earlier and result has been filed. 1 counter I received today. Only opposite number 1, 2, 5 appeared. Also 8. the owner. And today I received the copy from opposite part number 6. Mal 3, 4, and 7. Whether they have appeared or have not appeared, it's not known. They have not filed any counter till date.
Basically, Bhadrak municipality has not filed, he says.
No, I am appearing for number 8.
Yeah, they are private party.
8
is
has
your
filed
nursing home.
counter. 8 has filed counter.
Mr. Mishra, it is your nursing home.
No, I have sought copy, Maharaj.
No, it is your nursing home, I'm saying.
Rejoined.
No, your nursing home.
Your nursing.
Sir, my nursing home is there.
That's what. I just saw.
3, 4, and 7. 3, 4, 6, and 7. 7 appeared today. 6 appeared today.
Board manager, I have already filed the counter. State Pollution Board.
6. State Pollution Control Board.
No,
6, my lord.
Basically, this Bhadrak municipality is what he's saying.
Pollution Control Board.
Nobody's appearing for
All
Bhadrak.
clearances have been given. I have filed all the clearances.
I see.
But actually, they are running at a parallel nursing home there, orthopedic center. But that's a different matter, my lord. Your lordship to hear whether petitioner available by another doctor who has got an adjoining house, who is running an orthopedic center and an X-ray center without permission.
Who? This Bhagwan Bera?
He is actually, if lordship kindly see,
Dilip
another
Nayak.
writ application was filed by the wife of the doctor, and she claimed that I have violated everything. But in fact, they have violated, that is the law.
No, these petitioners.
No, my lord. No, petition have been set up by them. They are no way concerned.
I see.
But the allegation resides at set up. One of them resides at a faraway place. And these two persons have filed the documents annexed herewith, which are the annexed in the other writ application, obtained by PIL, right to information by the wife of the doctor. That how can you prove?
One more.
Yes. No, not PIL, the personal grievance. But this is the allegation made by the owner. All these documents filed has been borrowed from the other lady.
All right, let him file a rejoinder then. You not filed a rejoinder yet.
My lord, I am not to speak against this. Opposite party 8 has made various allegations against that lady, who is the wife of a doctor. But so we are not concerned, my lord, to decide whether the establishment is in order or not, whether the municipality has given permission rightly or not. So what is their locus standi, for lordship kindly ask, who are they? Petition number 1 and petition number 2, who are they? That your lordship to decide. No, you have to explain to them, because PIL says the concept of PIL is the person must have a locus to file an application. PIL is a locus standi. PIL, we are fighting for saving of the elephants. We have locus standi. My lord, there is a rule framed by the High Court. No rule is guidelines. No rule is available here.
1 minute. So you have, a civil suit has been filed, impleading the deponent's nursing home.
I have stated in petition.
You seem to have filed a
locus standi. Yes, my lord.
You have filed a civil suit.
I couldn't follow what it is.
Civil suit.
Civil suit has been filed in the court of the civil judge, Junior Division, Bhadrak.
Suit has been filed by the wife of the doctor. How we are concerned? She has also filed a suit. We are actually making similar allegations there.
Oh, I see.
Maybe, my lord. These two people might have heard from those people and have filed this writ application. But
So why-
PIL lordship is here.
Why use a PIL? This doesn't seem to be PIL at all.
PIL, my lord.
It seems to be a private dispute.
No private relationship. No, it cannot prove.
For relationship.
But
private dispute.
My lords cannot prove that the relationship. Where different persons, she might have filed a petition or anything.
Bhadrak municipality not filing a reply. Are you for the municipality?
Municipality. Municipality has not filed any counter. Municipality has given the permission. Permission is given. Counter to file is a party. I don't know who is appearing.
We should serve this.
Number 3 is executive officer of the municipality. Municipality is the real person, real party. Executive officer of the municipality, and 4 is special planning authority. These are to answer to the writ petition.
This is a small nursing home where 10 bedded for infant, my lord, actually pediatric center. But this pediatric center is serving the catering the need of the people there.
But that's not a matter for consideration by my lord. Pediatric center you would have challenged. That's not a matter. She is not a party.
Petitioners are affected, my lord.
She is not a party at all.
I'm asking a question myself, how the petitioners are affected.
Submit your lordship, my lord.
Actually, notice was accepted for opposite parties 1, 2, must be 1, 2.
Yes, my lord. 1, 2, and 5, my lord.
1, 2, 5, and 8, my lord.
No, 1, 2, 5, 5.
No, it was written as 1 TO. It should have been 1, 2.
1, 2, and 5 they have filed.
I know.
But 1, 2, 5 have filed counter. 6 has filed counter today.
I know, sir. But was notice notice never went to the Badrak municipality. You say it appears that on 22nd June,
but for 3 and 4,
the court recorded that the additional standing counsel bracket AC had accepted notice for opposite parties open quotation 1 TO 5 and 7, whereas it should have been 1, 2, 5 and 7 unquote. As a result, notice never went to opposite parties 3 and 4.
3 and 4, my lord. 3 and 4 and
actually that's
7.
Not filed any reply till date.
3, 4 and 7
now issued to opposite parties 3 and 4 by registered speed post. Returnable. On the next date, the tracking report will be placed in record. Based on 21st June.
The registered post should go, my lord.
Item number 59.
This is fixed to.
Your Lordship, this item number 59, Your Lordship, I may pray, Your Lordship may fix up a date, Your Lordship, for final hearing. Your Lordship, in these cases, the constitutional validity of Section 12 of the Odisha Value-Added Tax Act has been challenged, and assessment orders, consequential assessment orders. I mean, in some cases, pleadings have been completed, and in some cases not. Your Lordship, the with matter 10,865/2013. Yesterday we have filed the counter. Your Lordship, and the last matter 7794/2020. Maybe 4 weeks time may be granted for filing of counter. Except these 2 cases, in all other cases, counter rejoinder have been filed. Your Lordship may fix a final date of hearing of all these matters. And Your Lordship, by that date, these 2 cases, the pleadings will be may be completed, Your Lordship.
Your Lordship, in the first matter, the pleadings are complete. If state is relying upon those, then no further counter affidavit because it is only dealing.
Yes. First matter, counter rejoinder, everything has been filed. The second, the with matter 10,865/2013. Yesterday we have filed the counter.
A copy may be served, my lord. I am for the petition. I am on behalf of Mr. Anand Chandra Swami. Copy may be.
Actually, I could not find you yesterday. You can.
My lord, sub item number 6.
Yes.
Counter has not been filed.
Yes.
I have filed.
I have stated.
Use a list on 29th August. Replies be filed in those matters where it has not yet been filed within 8 weeks. Rejoinder for the next.
If you're order to be continued. Your Lordship fixes an early date. Mr. Gulati will be arguing the matter. If your Lordship fixes an early date.
No. Yes.
Well, interim order to be continued.
Yeah.
Interim order to be continued.
Yes. Interim order.
Obliged.
The matter is posted to when, Your Lordship?
29th August.
I see.
Item number 60.
May it please your Lordships?
Yes.
Your Lordships, I am appearing on behalf of Mr. BP Manti. This is a covered matter under your Lordship's judgment.
Covered, dismissed to it in view of Harishchandra Maji.
I am appearing on opposition number 3.
Harishchandra Maji. All right. Same one.
Item 61.
61 Lordship, no instruction.
Item number 61.
61 Lordship, and through virtual mode Lordship, there is no instruction.
No instructions dismissed. All right.
Item 62.
But here the petition is a license on-sub licensee. But here the government under Annexure 8, page 22, my lord, directed that you are operating in government land. But here, my lord, it is a municipality, and municipality has executed the agreement with me, and it is for the purpose of on-sub it has been granted. Annexure 4. But they have not filed counter. Even municipality also not filed counter. Notice is issued long since.
All right, final opportunity to the opposite parties to file the replies within 8 weeks, rejoined to the next date. Interim order to continue. List on. 27 September.
Interim order to continue.
September.
Item number 63.
In item 63, issue your in item 63, the issue before my lord is that whether the STB-LDS scheme shall be extended to the goods falling under 4th schedule, being not excisable, already covered by my lord's order dated 6th of January 2023 in the petition of own case, my lords. My lord, page 7, para 12, 13, 14, 15 is relevant.
All right.
Correction in para 14 is required, lordship.
All right. Same order.
In para 14, instead of 16th of December, it required 26th of December.
So we'll change this to instead of 13th February, 17th April. 17th April.
Para 14 also change your amendment, your lordships.
All right.
Grateful, my lord. My lord, one more case is left. 22845 of 2020. It's not the board. One case is left. 22845 of 2020.
Okay, you take that on board. 22845 and same one. The date will be the same for that.
Same. Yes, my lord. Grateful, my lord.
Item number 64.
Item 64, my lord, by order dated 14/11/22, my lord directed to furnish the present correct address of respondent 5. Hi, my lord. But despite my lord, he could not find out the applicant. Therefore, he filed an IA, my lord. I filed to take out notice by way of public by paper publication.
The reason stated the IA is allowed. The matter now be placed before the Registrar Judicial on 15th March for completion of formalities for substitute service, which will be made returnable on the next week. List on 30th August, 30 August.
I am for the respond number 1.
All right.
Item number 65.
Item 65, I raise a small adjournment, my lord. I am for the opposite party, my lord.
No, who's for the appellate?
My lord, also I found that some of the annexures are not properly page marked, my lord. It needs a little arrangement.
Who must go first, sir? You are for the appellate.
My lord?
You are for the appellant, sir.
Yes, I am for the appellant.
At the request of counsel for the appellate. List on. 3rd October.
Item number 66.
In order to continue.
May please your lordship.
Yes.
I mean virtual mode, my lord.
Yes.
Your lordship may kindly turn to page 51, the impugned judgment.
Here, my lords, admittedly, one D.R. Patra and sons had taken the land on lease to run a petrol outlet from the petitioner. We had no, I am for the Bharat Petroleum Corporation Limited, my lords. Bharat Petroleum Corporation had no privity of contract with the present petitioner. But she filed a writ application claiming rent and also damages. They also implicated me as a party. But in that case, my lords, the Honorable and the single judge had referred to the judgment of Joshi Technologies versus Union of India. And if your lordship has filed that judgment, if your lordship will kindly see that judgment at page at page 767.
No.
Joshi Technologies
judgment has been given, essay.
No, there are many judgments I have given. This is one.
No, Rudol's house Rudol's are relevant here, sir.
Because irrelevant it is, if there is no contract, he has given, directed to give this money as rent to the person. He has, as the honored single judge has assessed. This is a civil dispute after all. She has to go to a civil court.
Correct.
Can a writ court, my lords, allow this amount? That is my simple point, my lords.
Right. What do you say?
My lord, I am appearing for the respondent, my lord. The lordship can have a glance to Annexure 5, 30, my lord. Admittedly, there is no contract between the petroleum and myself, my lord. Those with whom I have the contract, my lord, he left the petrol pump. After that, I have requested the petrol company to remove their movable property.
But you have to
several times.
Well,
my lord,
you have to file a suit.
No, my lord. I have requested them to remove all their movable property, my lord. And they have negotiated me for the 3 years, and your lordship can answer Annexure 5, 12-15 October 2015, my lord. And my lord, paragraph 4, my lord, 1, 2, 3, 4. Your lordship got it. 4, my lord. Since retail outlet of the offer plot of land cannot be developed, we have therefore decided to remove our movable property latest by 13 November 2015, my lord. And we shall advise you very soon the exact date, time for more. They have not removed, my lord. I have, after waiting for 1 year, my lord, I have filed a writ before your lordships. That is on 15/11/2016. After 1 year, my lord. After getting the notice, my lord, they have removed all the articles from my place, my lord, on 24/2017. They have unauthorized taken my land for 17 months, my lord.
You have to file a suit for that,
My lord, your lordship, this honorable single judge has categorically stated that there is no privity of contract. However, since the oil company has unauthorizedly kept the land for 17 months, my lord. Your lordship can have a glance to, my lord. Page 54, my lord. Paragraph 7, my lord.
Yes.
Admitted position is the column did not have privity contract with the petitioner. That is why the petitioner made to go from pillar to post. Being an oil company, it has taken petitioner land anyhow. The two successive dealers were dealt with by the oil company in such manner that one was terminated and the other fled, ostensibly giving the oil company authority to enter upon the petitioner land. Petitioners have moved court for it exercise discretion against all the powerful oil companies.
How did this single judge arrive at 461,376?
My lord, that is the amount, my lord, I have given on rent to the earlier dealer, my lord. And that's
and you have no privity of contract at all. Then where's the question? Where's the question? So there's all completely. When there's no privity of contract, you can't get this money.
My lord, for the 17 months, my lord, after getting the notice,
you have to file a suit, sir.
They have admitted, my lord, they have kept all the material inside my premises for 17 months, my lord.
Yes.
My humble submission, my lord, there is no privity of contract, and the oil company has kept illegally, my lord, for 17 months, my lord. And it is a petroleum product, so that is why I cannot remove without their authority, my lord.
What do you say, Mr. Das?
Milord, he has calculated from the date Mr. D.R. Patra, who had entered a contract with him, that has been calculated and imaginary figures have been added. The rate as towards rate every year 20% increase. When there is no contract, Milord, 20% increase from which privity of contract he gets? 20% increase, Milord. He let him claim damages. He let him get lakhs. I have no objection. But can it be done in a read jurisdiction, Milord? There is otherwise anybody will come and say that. He has calculated from the date the previous dealer was who had entered into an agreement with him. He has not paid his due. He has added it to against the oil company. Your Lordship will go through the judgment. I will place that.
So the judgment that's been given is some other judgment, some rudul sa. That has nothing to do with this.
No, Milord, I don't know, Milord. I have given your Lordship. See the judgment which is relied on by the Honorable Single Judge.
No, Joshi Technologies.
Yes, Joshi Technologies.
Where is that?
I have given that much earlier. Paragraph 70, I am placing 70.8. If the contract between private party and state instrumentality and or agency of the state is under the realm of a private law and there is no element of public law, the normal course for the agreed party is to invoke the remedies provided under ordinary civil law rather than approaching High Court under Article 226 and 227. The very same judgment has been relied on by Honorable Single Judge. And there are two other judgments, Milords. For any such things, it must be the civil suit.
No, I have it here.
Money claim, after all, it is a money claim. 1994, 4 SCC page 450 have given the copy, Milords. Particular instance, money claims, involvement of any constitutional or statutory right essential. In the absence of statutory right, 226 cannot be able to claim any money in respect of breach of contract or tort or otherwise. And also another judgment I have given, Milords. The judgment which my Honorable Judge has relied upon, Milords, there it is specifically stated that. And he has increased by 20%. And the private person who had entered into a contract with him, his period has been included in my case. If your Lordship will kindly see the figures has been arrived at on his calculation. He has given a calculation that has been acted upon. Petitioner has given a calculation that has been acted upon and an order has been passed. Yeah, page 59, brothers.
39, sir.
I'm sorry. I'm finding out that. Petitioner has given his calculation that has been accepted by the Honorable Single Judge. Here, Lordship can 38 page, Annexure 7. His affidavit. And that has been accepted upon. From 1/12/21, there was a contract with a private person. He had a contract with a private person. That is 7,000 per month. From 1/4/2012 to 10,000 per month. From to 15,000 per month. It all requires evidence. What is the land value? What is the land will fetch? Nothing that matters. It is Honorable Single Judge has accepted that and passed the order. Whatever he has given the calculation at page 40, Milords, 4,61,000, that has been imposed on me. 4,61,376. Page 40, he has given that calculation.
All right. You see the challenge in the present writ appeal.
My lord, your lordship, that Lawrence Single Judge has relied upon the Joshi technology, my lord. my learned seniors has read the paragraph 78, but 79, your lordship, page 46, my lord. May I read the my lord? The distinction between the public law and private law element in the contract with state is getting blurred. However, it has been totally obliterated, and where the matter falls purely in private field of contract, this court has maintained the position that writ petition is not maintainable.
Not maintainable.
Next matter, the economy between the public law and private law rights and remedy would depend on the factual metrics of each case, and the distinction between the public law remedies and private law field cannot be demarcated with precision. In fact, each case has to be examined on its facts, whether the contractual relation between the parties be or insignia or public element. Once on the facts of a particular case, it is found that nature of the activity or controversy involves public law element, then the matter can be examined.
Correct.
That it can be examined by the High Court.
Correct, sir. Correct, absolutely. No difficulty on that.
Obliged.
The present writ appeal is directed against an order dated 22nd February 2022, passed by the learned single judge, disposing of writ petition civils 20056 of 2016, filed by the respondents. Whereby a direction was issued to the present appellant, that is Bharat Petroleum Corporation Limited, bracket BPCL, to pay the respondents rupees 461,376, along with simple interest at the rate of 4% per annum, calculated from 21st April 2017 till the date of payment, that is 31st March 2022, failing which the interest would be compounded with quarterly risks. Paragraph, while directing notice to issue in the present writ appeal on 20th September 2022. This court stayed the operation of the impugned judgment, subject to the appellant depositing the aforementioned sum together with interest at 10% per annum from 21st April 2017 till the date of deposit in this court, that is not later than 1st November 2022. The said amount was to be kept in a fixed deposit by the registry in the Nationalized Bank. Paragraph. This court has heard submissions of Mr. Shaktidhar Das, learned senior counsel for the appellate, and Mr. Tripathi, learned counsel, appearing for the respondents. 1 and 2. Background facts are that respondents 1 and 2 are the owners of land at measuring AC 0.150 decimal at Mojgorapalli in Khalikot Tehsil of Ganjam district. Stop. The land was leased out in favor of one Shri Golak Behra on 7th December 1988. Stop. BPCL had appointed the said Mr. Behra as a dealer who was operating a petrol pump under the name of Messrs. Taratarani Filling Station. Paragraphs. After certain irregularities were detected, the said dealership was terminated by BPCL on 14 June 2007. Full stop. On 28 September 2011, BPCL appointed Messrs. DR Patra and Sons as ad hoc dealer for the retail outlet. Full stop. The said DR Patra in his individual capacity entered into a lease agreement dated 1st November 2011 with respondents 1 and 2. Full stop. For reasons not clear, the said DR Patra abandoned the lease. Full stop. The landowners then made a representation to the Ministry of Petroleum and Natural Gas on 29 September 2015 for BPCL to vacate the premises. Full stop. On 12th October 2015, BPCL wrote to the respondents 1 and 2, stating that it was unable to accept the offer made by them for taking the plot of land on lease, but that BPCL had decided to remove the movable property therein, latest by 30th November 2015. Paragraph. Admittedly, BPCL was able to remove all the equipment from the premises.
April 2017.
On 20th April 2017. Paragraph. Meanwhile, respondents 1 and 2 filed writ petition civil 20056 of 2016 in this court. Praying inter alia for a direction to BPCL to remove all movable properties from the land in question and open quotation, pay the rent of the land to the petitioner, unquote. Paragraph. From the record of proceedings, it appears that after pleadings were completed, the case was heard with a single judge. First on 4th January 2022. Noting that after the filing of the writ petition, the BPCL had removed its effects on 20th April 2017. On the further relief to be granted, the learned single judge was held that from 30th November 2015 till 20th April 2017, open quotation, the oil company was wrongfully in possession of the property. Full stop. An adjournment was granted to enable the parties to report settlement upon negotiating the terms. Paragraph. It appears that at this stage, an affidavit was filed by the respondents 1 and 2, calculating the monthly rent from 1/12/2012 onwards and calculating the total sum payable to them as rupees 461,376. Stop. In response to the said affidavit, BPCL filed an affidavit on 21st February 2022, referring to the judgment of the Supreme Court in Joshi Technologies International Inc. versus Union of India, 2015 7 SEC 728, and contending that the original lease deed dated 1st November 2011 was itself an unregistered lease deed and cannot form the basis for fixation of compensation. And moreover, that The calculation was from a date prior to the alleged occupation by the BPCL of the premises in question. Full stop. It was pointed out how the respondents 1 and 2 had taken the base year as 2013 and enhanced the rent by 20% each year. And on that basis was claiming compensation. Full stop. It was pointed out that the appropriate remedy for the respondents 1 and 2 would be by filing a civil suit so that evidence could be left as to the nature and extent of damages suffered by the respondents 1 and 2. Paragraph. By the impugned judgment, the learned single judge has concluded that although the PPCL did not have a privative contract with the writ petitioners, the court was, open quotation, convinced that petitioners are entitled to minimum compensation, unquote. As regards the question of maintainability of the writ petition based on contract, the plea according to the learned single judge was, open quotation, contradictory to the oil company's own earlier contention of no privity of contract with the petitioners, unquote. It was held that the conduct of PPCL, a public sector undertaking, open quotation, shocks the conscience of court, unquote. Paragraph. The entire amount as calculated by the writ petitioners, that is respondents 1 and 2, was accordingly directed to be paid by BPCL to them in the manner indicated hereinbefore. The learned single judge observed that the judgment in Joshi Technologies International Inc. Supra had been adhered to. Full stop. Paragraph. It must be noted at the outset, this court has heard submissions, it must be noted at the outset that even respondents 1 and 2 admitted before the learned single judge that there was no privity of contract between them and BPCL. Full stop. Yet they were claiming damages for the period during which BPCL continued to occupy the land in question, that is between 20th November 2015, between 30th November 2015 and 20th April 2017. That is approximately 17 months, is it? No. 17 months. Full stop. The learned single judge appears to have overlooked the fact that the calculation made by the respondents 1 and 2 of the compensation payable to them was based on the lease agreement entered into with Mr. D.R. Patra, which itself was an erroneous basis after conceding that there was no privity of contract between them and BPCL. So further still, the amount was calculated from a date far earlier to the alleged date of commencement of the wrongful occupation by BPCL of the land in question, which was 30th November 2015. Stop. The calculation was made of rent payable from 1st December 2012. Thirdly, the rent was increased by 20% for each year, again based on the same lease deed, which did not and could not have applied to BPCL. Full stop. These facts were completely overlooked by the learned single judge. Paragraph. On the legal issue, namely whether a writ jurisdiction could be invoked for claiming damages, the learned single judge appears to have failed to appreciate that the judgment of the learned of the Supreme Court in Joshi Technologies INC holds contrary to what has been understood by the learned single judge. Also, the relevant passages of the said judgment read as under. Reproduce. Whereas 61, 69, 69.1, 69.3, 69.4, 70.8, 70.9 paragraph. It is plain from a reading of the above passages that the writ jurisdiction could not have been invoked in the present case when there was a contest whether damages were at all payable and at what rate. Full stop. As contended by BPCL, these issues could have been gone into only in a civil suit where evidence could have been led by both parties for the purposes of determining if and to what extent damages were payable by BPCL to the respondents 1 and 2. Full stop. The learned single judge, in the considered view of this court, erred in undertaking this exercise in a writ jurisdiction, and that too on erroneous basis, as explained herein before. Paragraph. The impugned judgment of the learned single judge is unsustainable in law and is hereby set aside. Writ petition filed by respondents 1 and 2 is liable to be dismissed. Full stop. The dismissal of the writ petition, however, will not preclude respondents 1 and 2 from instituting appropriate proceedings in the civil court for the purposes of claiming damages in accordance with law. The writ appeal is allowed in the above terms, no assist costs.
It may be refunded to us.
The amount deposited by the appellant in this court will be returned to it together with interest by the registry forthwith.
Obliged.
Through an authorized representative upon proper identification.
Obliged.
Item 67.
May I please, Your Lordship? Here in this writ appeal, the question is whether while granting a permission to transfer, under the Odisha Land Reforms Act, the concerned authority can impose a condition other than Section 22 of that Act. Well, I am a scheduled caste person. I applied for permission.
Yes.
The permission was granted. Your Lordship may kindly come to page 10 of the writ petition, my Lord.
We will take it up on some other day. Just say, list for hearing on. September 27.
Or may I pray some earlier date, because my mother is going to undergo a spinal surgery. For that only I want to transfer this land.
There's no date, sir. All dates are full.
My lord, the condition which is challenging in the appeal, that has been declared to be illegal by the learned honorable single judge, and matter has been remitted back. I'm just placing one line from the impugned order at page 9. At page 9, your lordship may see. Impugned order. In the circumstances, interfering with the condition aspect only remits the matter to the competent authority only to take a fresh view on the condition aspect so as to make the permission sustainable and strictly in terms of Section 20. Honorable single judge has held that it is the condition so imposed. This court finds that there has been already allowing the permission to sell, that it is excessive. The condition is stringent.
So why are you agreeing with this?
My humble submission, my lord, there could not have been a remand, because now the sub-collector will impose some other condition. Then I have to approach your lordship's again.
We don't know.
That is
Because made time bound, I think.
Because section 22.
By now it would have all been over, sir. You have gone and delayed it yourself.
Section 22, your lordship may kindly.
No, the instruction is that he has not appeared on that day. Sub-collector has given the.
Why did you not appear? There was no stay.
No.
Then why did you not appear?
I want a complete waiver, because usually he is imposing.
So your terms you want to determine it, sir. Then where's the question? You are not in a hurry at all. When the writ appeal date is given, you say, no, I need it for surgery. When you have to go back and appear in that authority without a stay here, you don't appear at all. Which means you're really not in need of that. You're not in any urgent need at all.
Madam, the question is, madam, my humble submission, section 22 prescribes only sub-collector is to see whether a person belonging to the scheduled caste community is available to purchase or not. That is the only prescription under section 22.
That is why
just a minute, please let me complete. Once the honorable single judge holds that that is bad, so the order of remand is bad. That is my humble submission. Because, and he is satisfied that no person of SC category person is available. He also finds that substantial land is also left with me after this transfer. That is why I draw your lordship's kind attention to page 10 of the writ petition. He has conducted an inquiry.
No, what is section 22?
Section 22, permission for
kindly see
transfer of a scheduled caste land to a non-scheduled caste person. So court has said that the condition imposed by the sub-collector is stringent and it is bad. So he has remitted back that you revisit the matter and grant the permission in accordance with section 22.
So then what does section 22 say?
Section 22, your lordship may kindly see. Xerox copy of section 22 I had given the other. Restriction on alienation of land by scheduled tribes. Any transfer of holding or part thereof by a royal belonging to scheduled tribe shall be void, except where it is in favor of a person belonging to scheduled tribe or a person not belonging to scheduled tribe, when such transfer is made with the previous permission in writing of the revenue officer. Provided that in case of a transfer by sale, the revenue officer shall not grant such permission unless he is satisfied that a purchaser belonging to a scheduled tribe willing to pay the market price the fine for the land is not available.
So why do you say he will put some other conditions?
And he put a condition.
No, that has been set aside.
That has been set aside.
Now why do you say now he'll put another condition?
My lord, what he is usually doing, my lord, in other cases, just a minute,
that
please.
That is a apprehension of the...
Please. He says adequate number of land should be purchased on the same day. That condition he imposed here. On the date of my transfer, I am bound to purchase similar extent
That's
of...
been set aside, sir.
That is set aside. What now he does, he says, all right, not on same day, you purchase it after 2 months.
How will he put such a condition which has been set aside?
Well, that is my humble submission. Once...
All right. You say the impugned order only remands the matter to the sub-collector for examining the matter afresh under section 22 of the Orissa Land Reforms Act 1960, after setting aside the condition imposed by the sub-collector for permitting the present appellant to sell the land to a non-scheduled tribe person. Paragraph
scheduled caste, my lord.
Non-scheduled caste person. The apprehension expressed by Mr. Mishra and accounts for the appellant is that the sub-collector will, on remand, impose another onerous condition beyond the scope of section 22 of the OLR Act. The court sees no reason for such apprehension. When the impugned order is very clear that the sub-collector should go strictly by section 22 of OLR Act, the court has no reason to expect that the sub-collector will either repeat the same restriction in the same form or in some other form as apprehended by the appellant. The court therefore sees no reason to interfere. The writ appeal is dismissed. The date for now the appellant to appear before the sub-collector is fixed at Fixed as 3rd April 2023. A copy of this order be sent forthwith to the sub-collector Malkangiri.
Public.
Right.
Item number 68.
My lord, in this case, there is an interim order that is passed on 14th/12. My lord, my instruction is that 10 days time may be granted for compliance of that last chance, 10 days. 14/12/2000. On 14/2/2023, your lordship granted some time.
Mr. Mohanty seeks 10 more days time to comply with the order dated 14/2/2023 at his request list on 4th April.
Item 69.
Item 69. Is sir not back? Mr. On behalf of Mr. Dal is not well today.
Fresh notice returnable 4th October.
Interim order to continue.
Interim order to continue.
Item 70.
May I please question? So in item 70, a small question arises for your lordship's consideration as to whether the complainant of a tax evasion petition is entitled to know the broad outcome of the tax evasion petition filed by him or not. That's the only question arises, your lordship. The law is in this regard is well settled, your lordship. I have enclosed some of the judgments
Let's see,
in rejoinder petition, your lordship.
let's see, may I request kindly take up on next 9th, because I don't have file. It is in the. I'm not able to.
Readings are complete.
Yes, sir.
For hearing on 4th September.
Item number 50. Pastor matter. Item 50.
May I please, Lord? My lord, here, my lord, the house of the petitioner was the meter installed in the house of the petitioner was verified by the electric authorities on 3rd of January 2023, and on 10th of January 2023, my lord, he was served with the provisional assessment order. Your lords will get at Annexure 3 series, and I filed my objection in view of subsection 3 of section 126 of Indian Electricity Act. Without hearing me and without giving me an opportunity of hearing which mandates the law, my lord, they passed the order.
Only relegated to an appellate remedy, sir. Why should we interfere with all this?
But your lords, you have a glance. For a moment, my lord, they have in the impugned order, they never served it on me. On 14th, they came to my house and gave to me in my WhatsApp.
All that the single judge has said, you file an appeal.
Appeal, my lord, but I have not been given an opportunity of hearing. Your lords, you have a glance.
You can raise that ground in the appeal, sir.
No, in the appeal, my lord, the condition is there that I have to deposit some amount.
What amount?
That is the...
That's all right. You can't avoid that by filing a writ petition.
No, my lord, but I have not been given an opportunity. Your lords, you have a glance on 163, my lord.
Yes.
126, my lord.
Yes.
The person on whom the notice has been served under subsection 2 shall be entitled to file objection, if any, against the provisional assessment before the assessing officer, who may, after affording a reasonable opportunity of hearing, to pass such order, final order. That final order is appellable, no doubt, my lord. But they have to give me an opportunity of hearing. That they have not given.
Correct. You can
That is my specific case.
You can raise that in appeal.
Well, let them give me an opportunity. I will have my say.
Yeah.
Then they may take my decision. That is my...
By the impugned order, the learned single judge has relegated the petitioner to the remedy of a statutory appeal under the Electricity Act 2003. Given the nature of the order, the court is not inclined to interfere with it. The writ appeal is dismissed.
I may be given some time to file appeal.